étudiants, membres de la communauté, tous et toutes, merci d'être venus et d'être venus nombreux compte tenu du fait que nous entamons ces semaines de relâche à cette dernière journée, quand même précieuse, exceptionnelle, du court mois de l'histoire des Noirs, afin de participer à ce moment historique en commémoration d'un chapitre névralgique dans l'histoire juridique canadienne. This moment surrounds the courage and conviction of one man, Mr. Fred Christie, a community member and the community that organized to support him, a series of legal decisions culminating at the Supreme Court of Canada, which remind us of the indeterminacy of law, and a necessary critical engagement with the persistence of racism and the law 80 years later. My name is Adele Blackwood. As the first Black law professor in McGill's history, I am distinctly honored to be able to recall the memory of the second Black professor in the history of the university, Dr. Kenneth Melvin, who was a pivotal part of the committee supporting Mr. Christie. It is in that spirit, and in the spirit of the bicentennial commemorations at this university, that acknowledges that its founder owned both Indigenous and Black slaves, and is learning that it educated and then hired as a full faculty member the first Black professor, medical doctor in British North America, and the first Black professor at McGill, William Wright. We are in an institution that is only now learning and reclaiming the depth of its history in, about, and through the Black community here in Montreal, in Canada, and throughout the African and diaspora and the African continent. So I take this moment to thank Principal and Vice Chancellor Suzanne Fortier for her words of welcome, printed in French and English in your program, and to underscore her special acknowledgement in that statement that this milestone celebration is also an opportunity. It's an opportunity to underline the historic links between the Montreal Black community and our university. And I quote, "Nous profitons de l'occasion pour souligner le lien historique qu'entretient notre établissement avec la communauté noire de McGill, de Montréal." This is meaningful to community, Principal Fortier, and I wish to acknowledge that formally. Let me also recall the intricate relationship between slavery, the work of settler colonialism, and the law. And in this moment, in which the rule of law is invoked as if it is the end of a conversation, I believe this faculty's century of Indigenous legal traditions as foundational to any reckoning with the past for reconciliation is not only prescient, but urgently necessary. With that, let us remain in reflection on what it means to acknowledge that we are on the traditional, unceded territory of the Kanakahaga, which is a founding nation of the Haudenosaunee Confederacy, and to acknowledge that this land also served as a meeting ground for other Indigenous nations, including the Anishinaabe. In closing, I wish to acknowledge the tireless work that has made this event possible. My co-organizers, Phone Amy of CRAR, who Facebook tells me is a leap year baby. Happy birthday. oldest Black congregation in McGill. They had the inspiration to make this commemoration happen. I'm grateful that they approached us to host this. I thank Zakia Jahan from the Labor Law and Development Research Laboratory, who's probably still outside doing a lot of hard work coordinating, Ayo Ogunremi and Tori Williams from the Black Students Network, Kagan Blackmore from the Balsa Canada, Balsa McGill here at our faculty, Mark Henry and his team from the Jamaica Association of Montreal, countless McGill colleagues and staff members, including Maître Véronique Bélanger and Maître Victoria Nico, Mesdames Lisanne Larose et Michel Sarrassin, ainsi que de nombreux assistants de recherche. Je tiens à remercier les invités pour leur présence aujourd'hui et d'envoyer leurs condoléances et nos meilleures pensées et nos prières à l'honorable Juanita Westmoreland Traoré et sa famille. Finalement, je voudrais remercier mon doyen, le Samuel Gell professeur de droit, Maître Robert Lecky, qui mène un décanat, je crois, inspiré, et qui tenait à ce que la faculté de droit contribue à cette initiative dès que je lui en ai parlé. Il me fait donc un plaisir de l'inviter maintenant afin d'offrir ses mots de bienvenue et afin de nous présenter M. Samir Zuberi, Member of Parliament for Puritan Dialogue. Merci.
Thank you very much, Professor Blackett, Uredell, distinguished guests, colleagues, friends. It's a pleasure and such an honor for me to welcome you all to the McGill Faculty of Law on this important occasion. I will MC the opening part of the program, but before introducing our first speaker, I will just say a few words of my own. As the structure of this afternoon's program embodies so elegantly, this afternoon is about looking back and looking forward. The first panel will take us deeper into Fred Christie, his moment in the 1930s, and his legacy. And the second panel will turn our gaze to racism in the law today, looking at the past and towards our future. Earlier this month, a second-year McGill law student named Fanta Lee published a text in our student newspaper, Quidnobi. It was entitled Black Faces in White Spaces, Reflections on Race, Disability, and Exclusion in Academic Spaces. And the author wrote that the hype around Black History Month was starting and left me with mixed feelings. This year's opening ceremony was to take place at the law faculty. Of course, as a Black law student, seeing my faculty playing a pivotal role in the creation of a meeting space for the McGill Black community made me proud. At the same time, it made me uneasy because the very space was also where I had experienced many challenges as a Black student. I don't presume to know what you will feel here this afternoon, but here are a few reasons why I have mixed emotions. Our formal legal framework has changed a great deal since Fred Christie's day. Legislation across the country and quasi-constitutional and constitutional instruments prohibit discrimination based on race. At the same time, it's hard not to sense acutely the limits of such legal texts. Access to justice, the difficulty of proving discrimination, which Fo, Nimi, and our students who intern at CRAR deal with daily. Our institutional failure, a good deal of the time, to breathe life into our often avowed commitments to substantive equality, not just formal equality. Our difficulty putting into practice our commitments to intersectionality and a seriously contextual approach. The seeming inability of our liberal legal system to deal with inequalities involving social class and poverty. Indigenous, Black, and other racialized people remain grossly underrepresented in positions of privilege and power, be it in the academy, in business, or in the legal profession and judiciary. Discussing racism remains harder than it should be. I think we're all aware how difficult it can be, it seems especially in this province, to get serious public conversation about systemic racism off the ground. And I want to salute our law student Balaram Holness for his success in this regard at the municipal level. I haven't yet mentioned recent public policy and legislation that differentially impact, if not attack, members of our communities on intersecting bases such as gender, race, and religion. Bill 21 is not the only example. Beyond Bill 21's immediate effect of excluding qualified, integrated citizens from full participation in public employment and public life, it encourages the majority to be suspicious of those different from them. It exacerbates conditions in a province where already the composition of the public service fails gravely to represent the population. As accounts of increasing incidents of Islamophobia and a quick dip into any form of social media, you can take your pick, will confirm, it is fostering conditions for expressing racially and religiously based hatred. White nationalism and supremacist discourse is on the rise here and in many other countries. So there's much to be concerned about 80 years after Christie in York, and much work yet to do. But there are also signs for hope, not least of which among our extraordinary students here, with their profound thirst for justice. I think among others of our Black Law Students Association, Muslim Law Students Association, Women of Color Collective, and Indigenous Law Association de Droit Autochtone, ALADA. Their eloquence, commitment, and capacity to organize and build coalitions inspires me. So my mixed feelings this afternoon include disappointment and rage, but also commitment to fighting and hope. Before we continue, I wish to salute the exceptional leadership of my colleague, Professor Del Backett, Canada Research Chair in Transnational Labour Law and Development, and the founder and director of the Labour Law and Development Research Laboratory here at McGill. She named the many co-organizers, but did not, of course, acknowledge the tremendous work that she has done in planning and executing today's event. So I'm very grateful, deeply grateful for the opportunity during my time as Dean to associate the Faculty of Law with this symposium and to host members of the community. We'll hear now from Mr. Samir Jabari, the Liberal Member of Parliament for Pierrefonds d'Allard since October 2019. He holds a law degree from UQAM and a mathematics degree from Concordia. And Mr. Jabari is no stranger to McGill. Until recently, he worked in McGill University's Faculty of Medicine, promoting the diversity and inclusion of Black students, Indigenous learners, students from lower socioeconomic backgrounds, and learners from rural areas of Quebec. He served on the University Senate. He's also served 6 years in the Black Watch, Canadian Forces Reserves Unit. He's a member of the House of Commons Standing Committee on Justice and Human Rights. Mr. Jabari, please come to the podium.
It's truly an honor to stand in front of so many people deeply involved and engaged in our society. I'd like to start by thanking Karar and the Faculty of Law for organizing this event that brings us together to talk about Black history, about the Christie case, to recognize the importance of celebrating racialized people, in particular Black Canadians, and contribution of Black Canadians to Canadian society. Today might be the last day of Black History Month, but it's not the last time that we will talk about the contributions of Black people and other racialized people and other minorities to Quebec and Canada. I won't speak too long. I have big shoes to fill. I'm standing in for our Justice Minister, David Lametti, who is actually also a professor here at McGill and was a professor for many years. But I will say that our government, the Canadian government, the federal government, is committed to diversity and inclusion, committed to working to make our society a better place, and is committed to ensuring that all racialized people, Black people in particular, are fully respected within Canadian and Quebec society. We know that there's a lot of work to do. We know that Black people in this continent and in this country have suffered discrimination over the decades and centuries. We know that there are a lot of stereotypes to undo, to unlock, to open up. We know that there's a lot of work to do. And we also know as a government today that this work must be more than words. It must be action, it must be funding, it must be programs and policies that are directed towards opening up people's minds, unlocking racism and discrimination. And for that exact reason, then in 2018, that we, as a government, we took the time to recognize in January the UN International Decade for the People of African Descent. This is a UN decade, one that started in 2015 and continues to 2025. But we as a government recognized it and put it forth within what we stand for. But more than recognition, we also put dollars to recognize and highlight this decade. We put $19 million over 5 years towards investing in Black youth and mental health for the Black community, Black Canadians. We've also taken time to invest in anti-racism, $45 million to combat racism within Canada. We are serious about this, but I think though, as a society, we must be serious. And you know, my path has started from protest to politics. That's how I started, 18 years ago. From protest, today to politics. And as I've gone through that path, I've passed through McGill, where I've worked here in diversity and inclusion to make this university more inclusive. All of us in the room are doing that exact same thing. And now, within the federal government and with my colleagues in Parliament, I actually take McGill as an example, along with other universities, the way how we are investing dollars in our education system to promote diversity and inclusion. Within McGill, within the Faculty of Law, within the Faculty of Medicine, within university structures in general, dollars are being spent to ensure that Black students enter the university, to ensure that Black professors are supported and Black staff are supported. I'll leave it at that. I'm here, I'll be here. I hope to meet you, to mix with you. My riding is a riding of Purefone Dollar. Those of you who are living within the riding, we're here to serve you. And the same goes for every member of Parliament. Every member of Parliament is here to serve you. So never hesitate to knock on our doors and to say that we'd like to have a conversation about around X, Y, or Z. Please never hesitate to reach out to us. Thank you.
Thank you very much. Now we'll hear a brief word from the representatives of the two co-organizers. First, Mr. Ponimi, happy birthday. Co-founder and executive director of the Center for Research Action on Race Relations, better known to, I think, to most of us here as CRAR. Oh.
Je voudrais juste dire quelques mots, Monsieur le député, Madame la Présidente de la Commission canadienne des droits de la personne, Madame la Vice-Présidente de la Commission des droits de la personne et des droits de la jeunesse du Québec, Madame Delanquière, et dans d'autres invités. On behalf of all of us at CAR, I would like first of all to thank the Faculty of Law at McGill and McGill University for co-hosting this. I would like to thank right away our three key volunteers, Zoe, Anna, and also Sarah for helping make this event very, very much a reality today. I would like to say a couple of things about Mr. Christie's battle, just to understand why we're here today, is that I believe that the speakers will speak to the fact that Mr. Christie's battle started way before Violet Desmond started hers in Nova Scotia. And way before Jackie Robinson came here to play for the Montreal Royals and gave the impression that Montreal was a haven for Black Americans and Black Canadians. So Mr. Christie's battle hopefully shed some light on that story. He was possibly the first Black man who went to the Supreme Court of Canada to fight racial discrimination. I think it's something that we need to look into further. And, but he remained for 80 years a forgotten civil rights hero. His case is mentioned in practically all constitutional law classes, but up until recently, few people knew his name, few people knew his face, and from today, we hope to change all of that, especially since last December, we asked that the situation be changed. We call on this country to honor Mr. Fred Christie, and for your information, we have made a proposal to Canada Post to issue a stamp in his honor. We have also begun work to submit to the Historic Sites and Monuments Board of Canada a proposal to designate him a person of historic national significance, and there are more measures to come. I believe that to honor Mr. Christie today is not only about a one man's battle, a family's battle, but it's also to honor the people behind him, like Dr. Melville, but also members of the English Black community and of Union United Church, many of whom are here today, in order to allow him to go all the way to Supreme Court. To rediscover Mr. Christie, il faut le dire que c'est une question de redécouvrir non seulement la place de la communauté noire anglophone de Montréal dans l'histoire de Montréal et du Canada, mais aussi de célébrer toutes les batailles et tous les efforts que tant d'autres personnes de la communauté noire anglophone de Montréal ont menés au fil des ans. Mr. Christie's case is the stuff that tales are told, heroes are born, and films are made. Hint, hint. We cannot wait longer to give him his rightful place as a person of historic national significance, because by losing a case before the Supreme Court in 1939, he actually won his for the years and generations to come. So we need those of us who are deeply committed to preserving the roots and promoting the legacy and the historic place of the historic Black community of Montreal. We do need another hero to make us proud and to make us whole, and I believe Mr. Fred Christie is that made in Montreal hero. So let his story be told, and his name be remembered for the ages, and let that of other Fred Christies of the city be told and known as well. I would like to end to invite you to join us in pushing for this recognition before the blanket is out. And in closing, I would also like to possibly pay special tribute to somebody in this room who also has played a very important role over the years, Dr. Esmeralda Thornhill, who is here with us today, and of course Ms. Nancy Oliver, who's been very tireless in preserving and promoting the heritage of the English-speaking Black community. Thank you for being here.
Please to call up Ms. Irene Anthony, representing Union United Church.
Bonjour tous, bonjour toutes. Good afternoon, ladies and gentlemen. My task is to take 2 minutes to extend a warm welcome to all of you. But before I do that, I'd like to extend sincere thanks to Dean Blakey, to Professor Adele Blackett, and to Paul especially for initiating this event. This is the end of Black History Month, but we are pleased that you've been able to allow us to fit this into your program. You have heard my name, Irene Anthony. I'm a member of the Board of Directors of Black History Month Roundtable. But today I'm really delighted to participating with you as a member of Union United Church. As we celebrate the courage of Fred Christie, I am pleased that the members of Union, some 80 years ago, supported the fight against racism. During its 113 years of existence, Union as an institution for decades has also had to fight racism and has often had to challenge the law on behalf of members of its community. Few of us were around or had been born when the case took place 1939, 1940, but certainly we are aware that Union spent a lot of time in the 30s and 40s fighting for justice here in Montreal, and we can credit the name of the Reverend Dr. Charles S. for spearheading that. Today, as we explore judicial recognition for human rights on Union behalf, it is my pleasure to extend a very warm welcome to all who have taken the time to be present here to help raise awareness of racism and the law. And so I extend to you a very special welcome to the distinguished guests who are here today. Some of them have been named, who will share their expertise with us. Dr. Blackett has assembled a roster of brilliant minds who will motivate us, who will challenge us, and who will enlighten us. And so on behalf of the planning committee, we're delighted to have you here. Welcome.
Thank you, Ms. Anthony. And the final speaker for this opening segment is Ms. Tori Williams, a student in McGill Faculty of Arts and president of the McGill Black Students Network.
Thank you, Dean Leckie and Professor Blackett. Good afternoon, everyone. My name is Tori Williams, and I'm the president of the Black Students Network of McGill. Happy end of Black History Month. It's been quite a month. So many different activities that we have put on. I'm just here to kind of give a little bit of a briefing of what BSN does. I'll keep it really short. But as some of you might know, the BSN has been at McGill since 1970, but our organization is rooted in a long history of student activism on this campus that dates back to the 1940s. The hard work and dedication of previous exec teams to foster community and advocate for the needs of Black students has translated into many of the events that you know and enjoy today, such as Black Talk, Youth Day, Soul Food Friday, Hair Day, for some of the students in the room who might have attended. In recent years, BSN executives have been working to acknowledge the many ways that Black students continue to challenge this campus through our community-wide commitment to justice, equity, and excellence. In working to properly acknowledge the accomplishments of Black students, an important realization for the BSN has been the essentiality of ensuring the widespread availability of our resources. To make sure that we can properly highlight the endeavors of all Black students, whether that be in academia, athletics, leadership, or volunteering, we need to make sure that students engaging in all of those areas are aware of the initiatives that exist to support and celebrate them. This year we have taken 2 significant steps in making ourselves more accessible. First off, at the beginning of the year, the BSN executive put on our first ever Black orientation event, which sought to act as a supplement to the main Frosh activities and aimed to provide Black students, specifically first years, a chance to familiarize themselves with the Black community on campus. We wanted to make sure that students knew that there are many organizations and spaces, including but not limited to ours, where it is safe to express and celebrate their Blackness. Secondly, to maintain and grow a community, it is crucial that progress is not lost or forgotten from one year to the next. The past few years, BSN exec teams have been consistently trying to improve our institutional memory through ventures such as the digitization of our archives and the creation of our BSN library. To continue this work, the current executive is working with my media to create a new website that will serve as an online database for information about the BSN, our archives, and upcoming opportunities within our service, within McGill, and the greater Montreal community. Being at an esteemed university such as McGill, the BSN understands the power of knowledge. We hope that our website can educate people on the prominent role of Black students, faculty, and staff in the development of McGill as a top academic institution. I think this is an extremely important topic today, especially with McGill's bicentennial quickly approaching. As the university celebrates its 200 years of existence, it is important to ensure that the contributions of Black people, of Black Montrealers, are not erased from the McGill narrative. It is with this reasoning that commemorating the Christie versus York case is of utmost importance. It has been BSM's pleasure to co-host McGill's Black History Month celebrations over the past few years. We are honored to be a part of the university's work to show the beauty and diversity of Black culture and how its evolution has influenced the transformation of society, and more specifically that of McGill and Montreal. Thank you to everyone who has supported the Black History Month team as we worked extremely hard to make this month fun, educational, and exciting. I'm so happy that we are ending this month on such an amazing event, and I'm looking forward to everyone who is going to be speaking later today. Thank you.
Thank you, Ms. Williams. It really sounds like the BSM is doing extraordinary work. Thank you for talking just a little bit about it. On passe maintenant au premier panel, qui sera présidé par Maître Tamara Dermitus, avocate émérite du barreau du Québec. Maître Dermitus a fait ses études en droit, en premier lieu, à l'Université d'Ottawa. Un peu plus tard, elle se spécialisait en droit de personnes, soumettant en mémoire maîtrise en droit ici, à la faculté de droit en 2013. Et ce mémoire portait sur les droits de personnes, notamment la discrimination raciale et la diffamation. Maître Dermitus était nommée présidente de la Commission des droits de personnes et des droits de jeunesse en 2017. Auparavant, elle était avocate du litige au Bureau régional du Québec, du ministère de la Justice du Canada pendant plus de 20 ans. Elle a agi à titre de négociatrice en chef pour le gouvernement fédéral pour la négociation du mandat de la Commission de vérité et de réconciliation. De 2004 à 2010 par ailleurs, elle fut présidente du comité sur les communautés culturelles du barreau du Québec. À ce titre, elle fut parmi les premières à sensibiliser les instances du barreau aux questions touchant la discrimination raciale dans la profession et dans le système judiciaire. En 2014, elle fut au cœur des travaux de recherche servant de base au rapport sur la diversité ethnoculturelle dans la profession d'avocat pour une profession inclusive, publié en 2014. Maître Dermitus a reçu plusieurs prix, dont le mérite du barreau du Québec, 2011, la médaille du jubilé de la reine Elisabeth, 2012, et le lauréate du mois de l'histoire québécoise en 2012 également. En 2015, elle fut l'une des 40 personnes à qui la Commission des droits de personnes et des droits de jeunesse a rendu hommage à l'occasion du 40e anniversaire de la Charte des droits et libertés de la personne. Merci de vous, Maître Dermitus, président de ce panel. Je souhaite à tous et toutes un après-midi très inspirant et enrichissant.
Merci. Thank you, Nikki, for those good words. Thank you for organizing this beautiful event. Thank you as well for your continuous commitment to make sure that Black people have a voice and institution, and make sure that this voice, and other voices are heard too. So I would like to start by inviting the people who's going to be part of the first panel to come and join us at the table. So first, I will invite Mr. Terry Brazil, the grandson of Fred Christie. So I would like you to applaud. And Mr. Barrington Walker, please join us. Mr. Terry Brazil was born in Montreal in 1953. He graduated from the University of Concordia in 1974 with a Bachelor of Commerce based on the curriculum from Sir George Wyman. Worked for the next 2 years at Bell Canada in their mid-management development program. From there, joined McDonald Restaurant of Canada, again in the management development program. Over the next 15 years, rose to the position of the Director of Information Technology moving to Toronto. In 1992, became an owner operator with the McDonald's in the Toronto area with one restaurant, currently still working in that environment, today now owning 4 McDonald's restaurants. I think it's also important to say that he was, during his career, he had been involved in very involved in his own community. He had numerous board positions, most notable the Scarborough Hospital as the chair of the board during the second outbreak of SARS. I think it's very important to acknowledge your knowledge about the epidemics, because I think that we're currently facing one and we're going to see what's going to happen. Is it as big as they promise? Hopefully not. But I'm sure that you're going to maybe share something with us about that. I'm opening the table because news is always important right now in our society. So thank you very much. I understand that you're here with your wife, and also that you have like 3 adult children, which you are very proud of. So thank you very much for being with us. I'm not able to say, because I read the decision, not in school, I read the decision with respect to your father when I was working as understanding my position in Canada as a Black person. As the dean said, I was in the university in the 80s. And at the time, those questions were not discussed, so we were like alone and trying to understand what is it, where are we, what is it, where are the information. So I had to build my whole knowledge by searching, and at the time there was no internet, so it was deep searching about what is Canada, what is our space, and what is it? Because me, I'm from Sept-Îles, up north, I'm une fille des régions, comme on dit. And I was the only Black person in my school when I was young. I was always alone. So trying to be part of the community is always a challenge when we came from a zone that there's nobody. The only person that you can, it's your parent and your sisters in my case. So it was very instructing to read the decision about what happened to your father, which is something that this was your grandfather, and it was very difficult, I'm sure, but you're there, and we're always there. We have to remember that we have slave blood in our body, so we're still there. And afterward, I would like to present Mr. Barrington Walter. Mr. Walter, and Mr. Walter holds a PhD in history from the University of Toronto and is a professor of history at Wilfrid Laurier University, and a senior advisor of equity and diversity and inclusion in the office of the Provost and VP academic. Before coming to Wilfrid Laurier, he was an assistant professor of history at Queen University. An historian of modern Canada, his work focuses on the histories of Black people, race, immigration, and the law. He seeks to eliminate the contour of Canadian modernity by exploring Canada's emergence as a racial state through its history of white supremacy, slavery, colonization, immigration, race segregation, that's made a lot of Jim Croism. Much of his work consider how these practices were legitimized and in some instances contested by the rule of law and the legal institution. Is the author of many books, and I think that he's going to address that about the book, The African Canadian Legal Odyssey, History Essay. Thank you to be here. Thank you to share your knowledge with us. Thank you to light the room about what is it to be a Black person in Canada. So, I will try. I'm sure that you're going to succeed. So me, I just want to say like a few words. I'm going to be very short. I think that what is important, it has been said in different words, the past is the present. we always have to remember that with respect to history, the past is the present. As Baldwin was saying, history is the present. We carry our history with us. To think otherwise is criminal. I would quote, and I won't do that for long, but the former Justice, the Chief Justice of Canada, Beverly McLaughlin, talked also about the notion of the past. She was quoting John Russell Sewell, saying the past is not the past, it's the context, and the past memory is one of the most powerful practical tools available to civilized democracy. So on those words, I would open up the table to Mr. Brazil, and after that we'll have the opportunity to listen to Mr. Walker, and I will be there to facilitate. So I think we want to see if okay. No, I think thank you.
Well, good afternoon, everyone, and bon après-midi. On the walk up from the hotel today, my wife was suggesting that I might want to do this in French. But I've been gone from Montreal for a little over 40 years, and I don't want to insult you right now, so if you don't mind, I'll do it in English. My name is Terry Brazil, and I'm Fred Christie's grandson. I'd like to begin by thanking Fo for doing this, the Center for Research Action on Race Relations, the McGill Faculty of Law, and very important, the Union United Church, who without their support back then, none of us would probably be here today. So thank you very much. In preparing to come here today, I spent many hours soul searching on what I could tell you about my grandfather. What would make you understand the essence of the man? I read some of the things written about him, being an activist and challenging the authorities of the time, but this conflicted with what I knew of him. He was the patriarch of our family, a kind, gentle man who was always a conciliator. So Fred, or as we called him, Pa, was so beloved by all our family and friends. He married my widowed grandmother in 1930 when my mother was only 10. That in itself was extraordinary given that my grandmother was a white Canadian woman of German descent with 4 children. Think about that for a minute. 90 years ago, that would have been almost sacrilegious. Now my grandmother, to say the least, was a little bit difficult to live with. But they were absolutely devoted to each other for 55 years until the day he died at the age of 83. He's buried in a cemetery not too far from the place they called home for some 40 years on Galilee Street in Candiac. My parents thought so highly of him that they named me, their firstborn son after him, Terence Frederick Milton. Frederick Milton being his given names. I can tell you that I idolized this man. He was always kind, loving, and even-tempered. In the original case, they make particular note that he was a gentleman. He's described as being impeccably clean, well-dressed, and the deportment of a gentleman, and an impressive manner in his carriage and speech. This is a very apt description of him. But what it doesn't say is that this man was a man of very high moral standards. In fact, I can honestly say that I'm the man today due to both his and my father's example and influence. Now, I obviously wasn't alive when the case surrounding Christie versus York occurred, so I can mainly speak to you about the man I knew and the conversation I had with him about the injustice he faced. I'm probably the only person alive that ever talked to him about the case. I was attending Sir George Williams University in my first year, when in my law class, we began studying a Supreme Court case, Christie versus York. Imagine my confusion and amazement that this case was talking about my grandfather. Confusion because I couldn't imagine anyone denying this man, my beloved grandfather's service. Amazement as I'd never heard this story before from anyone in our family. When I spoke to him later that day, he didn't have a lot to say about the case, other than the regret and perhaps profound disappointment that the case was lost. But not so much because it went against him, but more from the standpoint of how could this happen in the first place? It was just not right. Imagine, if you will, perhaps how different things might have been for the black community if this case had been won in 1939, and the country didn't have to wait decades to formalize everybody's individual rights. Now, I've read several reports that my grandfather moved to Vermont and discussed after the decision. First of all, that's simply not true. They did buy a farm in Saranac Lake, New York, called Breezy Acres, a couple of years later. And they spent part of the year there, usually during the summer. But that was more for a work environment than anything else. He was always a Montrealer at heart, and still never, ever missed a Habs game. He had a single season ticket in the gray section of the old Forum, and he just never missed a game. Secondly, my grandfather was not a bitter man. He did not let this decision define the rest of his life. He lived his life to the fullest. He was well liked and respected by everyone, no matter his race. My sister Joan and I look back and discuss that we lived growing up in a colorblind family. She tells the story in high school and having a friend over, and afterwards, upon leaving, her friend asked, "Why is your grandfather black?" My sister was taken aback. She had never even considered this, that he was any different. He was just Potter. That summed up my grandfather and how he helped raise us. And it explains what happened that night back in 1936 at the Tavern in the Forum. I recall him telling me once that when he was younger, that he was quite a firebrand. I look back now and realize that Christie versus York did change him. He evolved from an activist in his early years to the man that I knew, someone that we should all aspire to be like. A person who spent the rest of his life making things just a little bit better for everyone he came in contact with. And he would say we're all simply people. We should all enjoy the same rights and privileges. He stood up on July 11, 1936 for what was right. On that evening, faced with being overtly discriminated against, he saw an injustice and believed he had a duty to try and right it. As you know, he initially won the case, but lost on appeal and then lost as well at the Supreme Court. But today, if his story is being told to inspire a new generation of hopeful young people, this is the true remedy my grandfather would be proud of. I know that Fred Christie would not want you to hear his story and use it to inspire division, but to take his experience as a lesson in the power of persistence in community. It's these two virtues that allowed this man to fight his good fight while being the most loved man on the block. I'm so incredibly proud of him, and I'm proud to be here representing him. I know he's looking down on us today, puffing on his pipe and smiling. Thank you very much. Merci beaucoup.
Thank you, Mr. Brazil. Thank you very much.
Yes, I am. Well, it's a tough act indeed to follow a speaker who's directly related to the historical subject that we're brought here to speak about today. That was incredible. Thank you very much. It was a real treat for me this morning to hear that.
My pleasure.
I'd like to reiterate some of what was said earlier in the day and thank the organizers of this symposium, Professor Del Blackett and her team, as well as Foniemi and Crayar and the Union Street Church for bringing us all together today to mark this very important occasion, 80 years after Fred Christie, and to think about the complexity of the case and to also think about its contemporary significance for us. So I'm a scholar, as you heard in the opening remarks, of Black Canadian history, race, immigration, law, and increasingly, as I've been pushed by thinking about the past and thinking about contemporary events, colonization and the relationship that Black people have and other racialized people have to the racial, what I call the racial colonial state, I and others. I've not authored any extensive work on the case of Fred Christie. I'm drawing on work that has been published for this presentation, but I have considered this case and others like it in my broader work on Black Canadian legal history and increasingly on the notion of Black citizenship and civic belonging. Both of these themes for me are tied extensively to questions of the law. So my first book explored cases of Black defendants in Ontario's criminal courts, and the theme of belonging, among other themes, features prominently in this work. I've just finished a draft of a book on themes of race and colonization and the racial state, and one of the tasks in this book, again, is to think through the relationship of racialized people in Canada to racial state formation in this country. I'm continuing to explore the relationship of Black people in Canada to the racial state and the colonial state through a study of Black people and urban danger in Canada, urban violence, and also an embryonic study of the Honorable Leonard Braithwaite. So for me, Fred Christie's story gives me an opportunity to think about all the things that have preoccupied me during the course of my career. And also for me, it's an important singled out case, as legal historians are often want to do. They focus in on one case and try to extrapolate broader lessons and broader significance from singled out cases. But for me, also as an historian of Black Canada and an historian of Black modernity in Canada, it also speaks to a much longer, fraught, and complex history that Black people have with the law in Canada. So first I'm going to talk briefly about the facts of the Fred Christie case, and then I'm going to return to sort of teasing out what I see as some of the broader implications and the broader importance of the case. So on Saturday, July 11th, as our previous speaker noted, 1936, Christie and his two friends, one quote-unquote, I can't remember if they call them colored, I'm guessing they said colored, or black, and one white, entered the York Tavern, located on the ground floor of the Montreal Forum, which you're all familiar with. You should be, as we are in Montreal. And that night, a boxing match was taking place between a black New Brunswick boxer and a white opponent, which one scholar suggests features prominently in the outcome of the case, sort of the local context that was unfolding that night. So Fred Christie put 50 cents on the table and ordered 3 steins of beer, as was his custom in that particular place. On this particular instance, however, contrary to his past experiences, the waitress refused to serve him, saying that the tavern did not serve colored patrons or something to that effect. Christie then turned to the law for redress. The first time he would turn to the law, he contacted the police, who refused. When they arrived, they refused to help him. Outraged at his discriminatory treatment, Christie decided to fight back and sue the York Tavern. The case was argued before the Quebec Superior Court in February 1937, and in this particular instance, the court found in Christie's favor. The second trial was appealed to the Court of King's Bench, and that decision, unfortunately, went against Christie. By the time the case made its way to the Supreme Court of Canada, what you see emerging is a black community that mobilized its resources and mobilized its support behind Fred Christie. He's under the auspices, rather, of the Christie Defense Committee. And when the case made its way to the Supreme Court of Canada, and the court rendered its final verdict, Christie lost. What you see in the legal contests around this case are a legal contest between the right of free commerce and the right of Christie and other black Canadians in Montreal and across Canada to be free from racial discrimination. All of this in the absence of express law forbidding legal discrimination. In this particular instance, similar to other instances, the court moved to uphold the rights of the former, so that is the right of a proprietor to engage in freedom of commerce. As James Walker, Constance Backhouse, and Eric Adams have shown in their important work on the case. So I'm going to talk now about what I see as the broader context and broader significance of the case. And I'm going to end by saying a very few limited words about what I think is the ongoing significance of the case, right? The afterlife of this story. So I'm going to start by looking at what I believe to be, I think, one of the most important contextual considerations of this case. So I'm going to talk about the importance of the law in the era of slavery and then in the era of freedom for black Canadians. So slavery was extensively practiced in Canada, and much of the history of black Canada begins with the history of slavery. The law in Canada, as it was elsewhere in the French and British empires, was key in turning captured Africans, enslaved people, into fungible, movable property. The law granted property rights in slavery that gave institutional legal support in the parts of North America that were to become Canada. And during the post-slavery years in Canada, the years that one scholar named Sadia Hartman, in a different geographical context, that nonetheless calls the afterlife of slavery, the fight for social, civic, and legal equality that had been waged by black people has involved making the difficult move from their status as a property right to civil rights and full protection and recognition of full protection by the state. So there are two examples of the complex role of the law in the eras of slavery and freedom. The law plays a role in the demise of slavery by slowly chipping away at its legal foundation. And this chipping away in history classes in law schools is often represented in a rather triumphalist vein, celebrated by scholars as what's called a judicial war that's launched against slavery. I've always maintained that this is a bit of an exaggeration because at the same time, these very same jurists were unwilling to expressly use the law in British North America in particular to abolish the institution of slavery. And second, you can see the ambiguous role of the law vis-a-vis black people in the realm of civil rights and Canadian Jim Crowism. In this case, legal equality was hindered by attitudinal and cultural discrimination in Canada. And the paradox faced by blacks in their appeals to the state for full equality. Building on the work of others such as James Walker and Sage Matthew, I have written about the nature of the institutional and attitudinal, anti-black racism in Canada that amounts to a historically, to a Canadian version of Jim Crow. And this Canadian version of Jim Crow, with a few notable exceptions, did not involve formal legal equality, but rather in Canada, the state tended to recognize the individual's right to discriminate, whether in terms of the freedom to associate or to do business with whomever one pleases. And this principle took myriad forms in terms of segregated schools and places such as housing discrimination, places of worship, private establishments, even had segregated cemeteries and hospitals in Canadian history. So the difficulty that African Canadians had when trying to fight these forms of discrimination was, to paraphrase African Canadian civil rights leader Bromley Armstrong, was like fighting ghosts or apparitions in the dark. In the absence of positive law, in the form of, say, the Jim Crow laws that existed in the US, or parts of the US in any case, the full fight for full civic equality in Canada was in some ways always more difficult in the Canadian context. The courts in Canada during the era of freedom, as they were during the time of slavery, were rather timid historically with regards to imposing legal remedies to address racial inequality in Canada. In contrast, in the United States, Black Canadians would have to rely on legislative measures, and I'm sure people in the second panel will say more about this, to combat racial discrimination. Examples are the Fair Employment Practices Act of 1951 and the Fair Accommodations Practices Act in 1954, to cite two examples in the Ontario context, as well as the human rights codes that emerge later on in Canadian history. And I will suggest later that human rights law and human rights codes have had a mixed legacy for Black people in Canada. So for me, the case of Fred Christie sits in that long era after slavery and emancipation that Robin Winks, I think, very aptly referred to it as the nadir of the Black Canadian experience. That long period after slavery and before the emergence of human rights legislation that I had just referenced in my remarks. That period between 1865 and 1930 was the nadir of the Black experience in Canada, I believe, for reasons that require us to go beyond purely legal analysis today. The law was embedded in and a part of a larger conversation. The period after 1865 witnessed the end of the American Civil War, the end of slavery, and the end of the Underground Railroad, which has a mixed legacy in Canada in any case. The period also witnessed the hardening of racial attitudes through the emergence and rise of biological racism or racial naturalism. And its counterpart, liberal racism or environmental racism, began to recede in the wake of racial naturalism. The Fred Christie story and its details will be further examined in great detail today, I have no doubt. His entry into the bar with his companions, the refusal to serve him, as per their stated or unstated but otherwise known policy, Christie's outrage at the decision, no doubt fueled not only by a real sense of racial injustice, but also, I would suggest, contemporary Black respectability politics as well. Christie's fight all the way to the Supreme Court, and the Supreme Court decision that affirmed white supremacy under the formal legalist cloak of freedom of commerce. And all of this happened in the context of the Great Depression and a rising tide of Quebec nationalism in the interwar period, as well as anti-Black racism during this period as well. Others will speak today on the contemporary significance of this case, and I do have some to say about it. I will ultimately defer to my colleagues who are here to address precisely this issue. I will say a tiny bit though. But as I alluded to earlier, this case cannot be understood outside the long trajectory of the history of Black people in Canada. I have argued that the big story of Black people in Canada is the journey from fungible property, recognized in property rights of white people, to rights-bearing citizens. When slavery was abolished, so too was whites' property rights in Black people. But the other part of the journey to rights-bearing citizens has been far more difficult and ongoing. So what I'm trying to say here is that I don't believe that Black people in Canada today are fully rights-bearing citizens in Canada, and it may be well timed to ask how long we keep looking to the racial colonial state for that kind of recognition. I also find this case, the case of Fred Christie, fascinating because it is a window on the complicated, or perhaps not so complicated, relationship that Black people in Canada have had with the law. As Professor Blackett mentioned in her opening remarks, Indigenous people today are routinely admonished for not respecting the rule of law in acts of civil defiance and civil unrest. Campaigns, or such campaigns of various types, and they resist the hegemony of the Canadian state. What critics point out, however, is that the rule of law is also the basis of colonial power. The law is not a neutral set of rules, but the very stuff of the colonial state. Black people, I'm going to suggest to you, faced a similar problem where the law was concerned. And frankly, in some ways, the relationship between the iterations of legally supported anti-Black racism in Canada, what I've called Canadian Jim Crowism, were similar to the situation faced by Indigenous people vis-a-vis the law. The law was used to support the social status of Black people, the subordinate social status of Black people. It is also the primary tool through which Black folks have resisted their condition. There is then a story of resistance here that many of you have already alluded to that is really important. And Fred Christie's fight for equal rights is an important narrative that must not be lost. And I think we're here to celebrate that legacy today. Nor should we ever lose sight of the fact that Black people did not sit quiescently and complacently in the face of their subjugation. Indeed, the fight that Christie launched did provide much of the basis for the broader fight for inclusion that was to emerge after the Second World War. And as other scholars have pointed out, the whole framing of the rights revolution as a post-war phenomenon is, strictly speaking, not accurate. And I think Fred Christie's case speaks to that. The seeds of the post-war rights revolution were sown long before then, long before the post-civil rights, the post-World War II era. That said, the historically complicated role of the law, both upholding white supremacy from the property rights to free commerce, has always limited its effectiveness, I would argue, as an emancipatory tool. And for me, those are some of the big questions that face us when we're thinking about the historical legacy of a case like Fred Christie's. It's whether the Canadian state and whether the same law that supported slavery can in any meaningful way support freedom and equality, but more to the point, Black freedom and Black equality. I want to suggest that Black people have never fit with the figure of the universal subject invoked in traditional human rights discourse. And this to me is the root of the problem with human rights law. And I'll conclude by saying that you can see this in the context of some of the social movements that have emerged today, such as Black Lives Matter. Black activists across the country have grown impatient with rights-based avenues to social redress. Black communities in Canada, though again vibrant and resilient, are mired at the bottom of the socioeconomic hierarchy in Canada. A perpetual outgroup. And now, as in our historical past, other groups use anti-Black racism as a way to ladder into Canadianness and as a way to ladder into whiteness. We face mass incarceration, we face police violence, And serious questions, uncomfortable questions, need to be asked about the relevance of human rights law to recognize the basic humanity of the descendants of slaves in this country. Thank you very much.
Thank you, Mr. Walker. I will open the floor for a few guest questions. Yes, that's a rare question. Maybe a few questions. And we'll back on that. Yes. Yes.
There's no mic.
There's no mic.
There's no mic. Okay, so my question is for the last speaker. I have two questions for you. I hope you hear me. The first one is basically there's a distinction in law between social and economic rights and between civil and political rights. And I'm wondering if I guess the fight against racism has suffered from that distinction, because as we know, the law is really good at protecting civil and political rights and not good at protecting social and economic rights, which means that people who live in racialized people live in poverty are not protected by the law. That's the first question. The second question, you talk about the universal subject. Do you think that there is some basic problem at the heart of the liberal tradition that would basically perpetuate the problem that you're talking about with the universal subject? And if so, do we need a post-liberal legal order? Not an illiberal, but post-presupposing the idea that we incorporate what's good liberalism, but we still need a post-liberal legal order.
Thank you.
Thank you for the two easy questions. So what I'm going to say in response to the first question is that that's always the limits of it. And, it's not my purpose to come in here and unnecessarily provoke jurists and legal scholars, because I do see some that there has been some benefit from rights-based discourse. Right? It does have an important history, and it does have an important legacy. And it is important that institutions like this open themselves up to demands for inclusion and equity and diversity and all those things. But I think, in answer to your first question, I think that precisely is the limits of human rights law. I think that even if you look at it, people in this room know more about it than I do. If you look at our charter, where it stops short for me is giving Canadians a material basis. And I'll put if you Google me, I'll put my political biases out on the table. I am a social democratic socialist. Democratic socialist, both in terms of my academic work and my political practice, and I think that's where the Constitution stops short for me, is that it stops short of material guarantees to support a rights-based regime. So I would agree that human rights law is generally good at protecting civil and political rights. Socio-economic rights, I think, is an ongoing problem, particularly the ways in which socioeconomic inequality, as you all know, is linked to race and racism. So that's one of the primary ways that race and racial inequality are perpetuated materially and through class, right? So for me, it's trying to distinguish whether it's race or class or gender that subordinates people or sexual identity. It's like trying to unscramble an egg. So I would agree I would maintain certainly that's one of the problems with rights-based discourse is on the question of materiality. With regard to the universal subject, without going into great detail about it, what I will say is very briefly that the universal subject was never universal. And that is one of the problems of rights-based universal discourses, is that that kind of discourse is very impervious to things like the reality of colonialism and slavery and anti-black racism. And I do recognize somebody might say that, well, that's always been an important part of the social struggle of black people is to kind of invoke that idea. At least that's one tradition anyway of black social justice struggle, right? To invoke universal humanness and the universal rights. But I think that if you look at the very genesis of that idea in the first place, that it never was meant to include people of African descent. So whatever that future looks like, I sometimes wonder whether we can get to where I want us to be from where we are, right, within that paradigm of universal humanness and universal rights. I think I think it's going to be very difficult to get there from where we are, and I think the historical record has shown that it's spotty at best. So I hope that answers both questions.
Sir?
Hi, Dr. Walker. I'm just wondering if you can perhaps shed some more light on your thoughts of the alternative framework to the rights-based approach.
More easy questions. No, that's a really good question. So I mean, I think it aligns with what I said some of my values are. So it's not about, for me, it's not about completely jettisoning a rights-based approach. But I think there needs to be, and I think there has been, if you even look at political events south of the border, not so much in this country, interestingly enough. But if you look at how the political conversation is trending, how liberalism is being transformed, and in the United States right now, to the limit that I saw somebody come across my social media feed, I can't remember who it was. Some prominent American journalist had said that Bernie Sanders was the death of American liberalism, not its full realization. And I didn't get a chance to read it, but I want to hear what the argument is. But I think that at least you can see in the United States that there is that material critique of traditional rights-based discourse and traditional liberalism is beginning to take hold as people look around and realize, particularly in a time of really profound wealth inequality, and not that wealth inequality is new for people of African descent, but I think that the way that advanced capitalism has developed in the last 20 or so years, there are a lot of people waking up to reality that, there are some really gross material inequalities baked into the system. That thinking about material concerns beyond rights-based notions of equality are beginning to really transform the electorate in that country. So that's how I think I would want to move beyond purely a rights-based framework for addressing issues of inequality, is thinking really seriously about materiality. And these aren't new. I mean, that's not a new idea, but I think it's an idea that's beginning to reemerge because social inequality has become to a vulgar extent, social inequality has become so pronounced in our society. So the traditional ways in which folks at the very bottom of the socioeconomic hierarchy were given at least certain basic guarantees that they could have a place to live, have a decent job, and I mean certain folks, I mean mostly white people. That social contract has been thrown out, and people are not happy about it. So that's how I think I would answer that question.
Last question?
Yeah, my question is for Mr. Brazil. My family is from Jamaica, and when I think back to my grandparents, they were involved in small entrepreneurs in the banana industry, and in the early part of the 20th century, there was sort of this sweeping Jim Crow that came from the U.S. large banana companies. I'm just wondering if you can recall what your grandfather's memories were of his youth growing up in Jamaica. I mean, he came to Canada for a reason. I'm just wondering if he reflected on his youth there, his own family.
Why he came to Canada? He felt he had better opportunity here back then. And you know, if I were to gauge this now, I didn't know him when he was a young man, so only you know, stories he would tell me. He was somebody that you could, and I'm trying to, he integrated in Canada. I mean, there was no ifs, ands, or buts about it. And we probably should look to him and the way he lived his life, that he made a difference to everybody. That he the fact that somebody refused to serve him it would be foreign to me. I never knew anybody that ever looked at this man and said no to him. And it wasn't that he was arrogant. It was just his mannerism of making things right for people. He was able to take an issue and find common ground. So I wasn't there when he came to the country, but he became Canadian, and there's not a whole lot more I can say. I mean, I know where you're going, and I was pretty young at the time too. So, but yeah, I mean, he came here for opportunity, and if I were to gauge his life, he found it.
So, okay, but I'm going to give you because we're running a little bit late. That's okay? Okay, that's good. So go ahead with the question.
So my question is, you said earlier.
Can you speak louder, please?
Sorry about that. You said earlier when you guys were younger, your sister and yourself didn't really see your grandma as a black person, and that later when you were in school, you heard of the case, and that's the first time you heard of the case. After the case, did that, when you reflect back later, have any impact on? Did that case change your view on whether or not the community as a community at large saw any distinction or difference? So you say you didn't see it as a child, you heard the case, after the case, upon reflection, did that change your view of things earlier or not? Was that
Yeah, no, I was incensed when I read this, okay? It absolutely was totally foreign to me. How could this be? And I talked to my mother about it, how could this be? And I asked her, how could this possibly happen? His way of looking at life was he would work to solve the problem. And so as I said, he changed, this case probably changed him, made him more of the gentleman that he truly was to begin with. But, I was more incensed than he led me to believe. It was just, very, very disappointing. I could see it in his face that he was disappointed by it, because he had to think about it. Remember, when I'm talking to him, it's also 40 years after that happened. So yeah, he was. It didn't change him, and it didn't change the way we were. It's when I say we're colorblind, we're colorblind, and for me, growing up with him, that's what he would have wanted me to be, and that's what the family was.
But for us in the judicial context, colorblindness is an issue, so maybe that's why the question is raised. Because the notion of colorblindness is not to recognize the fact that there's some discrimination and some disparate treatment. So when we see, I understand that he's a youth, for us maybe, and I'm talking as a lawyer, it's maybe to see him as a human person and try to to fit in, but the notion of color blindness, and some professor who are like confirming by saying, is that it's difficult because if the law is colorblind, the law does not address the issue that minority suffers, or like woman suffers, because the law, as my colleagues say, the law is not neutral. So for us, when we raise the notion of colorblindness, it's like forget that the law is not neutral. So the law is not neutral. So when we engage in any institution, we engage in institutions that are based on power and on differentiation of power. So that's the point that when we talk about colorblindness, I think that's what I sense is that the idea that he was colorblind as an individual, that we all try to be colorblind to fit in, but at the same time we know that we have a color and we have to live with it. So it's that challenge that we currently have. And my father was colorblind too, and he was a dark man, but what he gave us as a legacy too, and he was a man who was born into 1926, he wanted to be colorblind too, but he was a black man. And he suffered from the fact that he was a black man having difficulty to find jobs and stuff like that. So that's the issue with the notion of colorblindness.
But I just to touch on it, they used to let my grandfather park his car in the forum, where he was being discriminated against. I mean, there's not a parking there, and that's the way individuals looked at it. It was just, he was Fred.
He was part of the community.
He was absolutely
part of the community. Yeah, and the tension, I think, is not about the individual. The tension is about the notion of colorblindness in the general context. Not that, because I understand that sometimes as a black person I have no color, but sometimes as a black person in a white space I have a color all the time. I have to deal with the fact that I have a color, but sometimes I have no color. When I live my life as a person, I see myself as no color, but when I get outside, sometimes I saw that I have a color, and I cannot change the color of my skin, and I cannot change the fact that I'm a woman. So when you talk about intersectionality, that's also the same thing. I cannot say that I'm a black woman. So the fact that you become a black woman, you have like some stereotype that fit with what you're supposed to be or the way that people sees you. I
always wear glasses. I have a short comment and then not so eventual question. Just loud.
Loud. Be loud.
Oh.
You're allowed to be loud.
Okay. All right. I have a short comment first. Okay, for Mr. Brazil. To me, it all boils down to the victim, right? First and foremost, the victim. That's what we're here for today. And Mr. Grandfather was a victim of discrimination back in those days.
Now
he was a victim,
yeah.
And that's what we're here for, is really talking about it intellectually, but it's really boils down to the victim. Obviously, Grandfather was extremely resilient. He was a resilient man, supported by the community. Without that community at the time, I don't think he would have gone that far, right? And we wouldn't be here today if there wasn't a community supporting him as a black man, trying to assert his rights, which really we would never recognize, was solely debated on the issue of freedom of comments. Has nothing to do with human rights as far as any government or any society was concerned at that time. So colorblindness. So my question is this, for Mr.
Walker?
I've got 2 of your books, by the way. So I've read your books, which really I recommend to everyone in the room that hasn't read it or bought it. I've got 2 of them.
Thank you. I did not.
Very enlightening in terms of our own Canadian history. Of course, the argument is that this whole Christie affair happened 80 years ago. Right? A whole lot of water going on the bridge. There was no Bill of Rights. There was no human rights. There was no charter that could call a roll. So things obviously are different today. This would never happen today. That's the argument. That is the argument that obviously a lot of us that are not in the room would make. So we've got to think about people who are not here, because those are the people we have to educate, right? So the notion of colorblindness, because I believe that the Canadian society back in your grandfather's day, all the way through, and from what I'm reading from your book, sir, the whole issue of color blindness has always been in existence throughout Canadian history. So that we are in a place now where, when we're fighting human rights, discrimination and whatnot, the prevailing attitude and narrative in the majority community is that we don't see color. It doesn't exist. The law or legislation are passed or made without any particular care of race, creed, color, gender, sexual preferences and whatnot. And certainly when applied, judges don't see color, they just apply law. And I think, to me, that whole notion of colorblindness has been very pervasive in sort of affecting the way the law is granted today. So I'm asking a question to Mr. Walker, what needs to happen to change this narrative of colorblindness, which in my book, I might be way off and you can correct me if I am, which really at the heart of the way human rights and civil rights are being dealt with through the court system and with other institutions that are supposed to be out there to preserve our rights.
I think a couple of things. I think one of the things that human rights law actually does do, if you look at the way that it's laid out, it actually does recognize racial differences. It isn't color-coded. Although, and in that sense, I think it is a break from previous traditions of British jurisprudence. I think in broader Canadian discourse, a lot of the old, so I mean broader, outside of the form of legal formal law, I think there's still a lot of that colorblind stuff that kind of floats around. One example comes to mind. I don't want to mention it though because it's going to sound highly partisan.
Go ahead.
No, I won't. But just
We're gonna beat it.
I'm not going to mention it. But I think in a lot of broader Canadian conversations that comes through. I think in some ways, in terms of multiculturalism, some of that also comes through the way that people talk about multiculturalism. It's about race, but it's also framed in the language of culture, which I think is part of that old kind of British colonial hangover in terms of not wanting to mention race. I think one of the ways that we combat color blindness is to do the really difficult work. Any legal scholar of race in Canada that's researching British common law, one of the problems that we have in terms of trying to excavate cases about race is that it's a traditional, well, they're there, but they aren't named. So if you're doing legal research in a place like Tennessee, it will say, Jim Bob stole a chocolate bar colored, right?
Yeah.
And Canadians would go, oh, that's so terrible, they call it colored. Here, you don't know. So you read some of these legal cases, and there's all this stuff that happens, and you kind of suspect there's a racial element, but it's not in the legal record. So you've got to go outside the legal record, and then you have to read that back into the case, and that's the only way some of these things actually make sense. You've got to look at newspapers. Sometimes you get lucky, you look at judges' bench books or jail records. And there's all of this work to excavate race, right? And that's part of what color blindness has done in this country, is to make it really difficult to excavate the history of racial inequality. But I will say this, in defense of Fred Christie and in defense of his descendant, I think that 1930s Canada was a very different place in some ways than the country that we exist in now, kind of pre-Black Power. And I think that we got to be careful about judging somebody who told his family to be colorblind at that particular time. I think it's, I don't know, I'm not saying that's what we were doing. I know that wasn't your point, but I think, we have to be kind of sensitive about the time that he lived in, and also sensitive about the fact that, they were frankly, this is an uncomfortable conversation, but around the 1930s, if you look at that census, the Black community in Canada, the numbers just dropped, right? I can't always remember the numbers, but there's a precipitous drop in the reported Black population. And that's just because of a lot of Black Canadians during that time, they just passed, right? They just say, to hell with this, like, there's no way that we can combat this. So those folks who have proximity to whiteness just decide, right? You get out of the place where you live, where people know, oh, that's a colored family down the road, and if you're light enough to pass, you move, and you pass, right? And I have all sorts of conflicted feelings about that, but you know, what I know about the kind of violence that was enacted upon black people during that era in Canada, it is hard to judge. So I know that's not what you were saying. I'm speaking to some of the broader kind of discourse around Frank Christie's personal politics, right, and his ideals and how you move through the world. I might not agree with everything, but as a historian of that era, I'm sympathetic to what black people were going through in Canada during that time. I mean, there are times when I researched my first book that I was in tears and I had to leave the archives because I didn't recognize that Canada that I was reading about in the archives.
Last question. Yes.
I'm not an historian per se, and I'm a lawyer, and I do cultural studies, and I study skin color quite extensively. And it seems to me when we're talking about color blindness, one makes an assumption that whiteness is embedded color. White is a color too, and we don't call it a color, but it's an embedded assumption that color is different from whiteness in that comment. I mean, I think that it's really important to recognize that when we talk about color blindness, that color blindness involves a lot of people who are light-skinned as well, who don't recognize that they have a color, and that it's a kind of consciousness. Everybody has a color, and I just wanted to sort of lay that out because when I hear the term color, I guess applying to more blindness, who's colorblind in that process?
I didn't want to suggest for even a microsecond that there is no racism here. I'm trying to tell you the way my grandfather looked at things, and it was just a person was a person, and I mean he was so integrated in I mean we adored him, and anything he said was like coming from on high. So you know, there was nothing to consider that you wouldn't even. I used to look forward to when I was a young boy sleeping with him. You know, I said we're going to camp on, and he said, "Yeah, come on." He was just a man. And I think that's the way we should all be. It's just a person.
And that's
that's why I said a person. Because my wife will make me know it.
But I was referring to the idea that the poster, I am a man, you know, that was used in the 60s. In that sense that I said I am a man, I am an individual, I am a human. That's something that was happening in the 60s. So just to say, we talk a little bit about resilience. Just to inform you, this week, Stat Canada offer like some insight about Black resilience, and they say that the information was out, I think, February 26 or 27. So I will quote what they say about Black resilience. Black individuals demonstrate strong level of resilience even when faced with hard times. In 2016, 44% of Black individuals say they were always able to bounce back quickly after hard time, compared to 33% among the rest of the population. So it's kind of embedded now in us, so it's part of Stat Canada now. And yeah, the thing is that, you know, hardship is hardship, and we talk about the fact also there's this question of discrimination are still very strong. The fact that the Black men of both the employment rate fall and the unemployment rate rise over time. The data are still the same. some data saying that most black youth would like to obtain a university degree, but proportionally they are less likely to think that they will be able to obtain one. So those questions are critical in our society, that what kind of inside racism, that they integrate racism of their own self. And that's a big question for society. How can we have a society that the youth, and I think that it will be the same for Aboriginal people, that they are like, the society tell them that they won't make it.
Yes.
And they accept that they won't make it. So I think that's food for thought, and one of the things that is interesting also in the decision that when I read, because I read it with a lot of interest, right? Because I read it 3 years ago, I read it last night, and you have to remember also that Christie was again a corporation, not an individual of the Congress, but a corporation. So the corporation are more right to the liberty of farmers than the dignity of a person. So when you look at the imbalance of power again, it's very strong. And there was a line also that when we talked about your grandfather, the judge said that he was, and I will quote, not extraordinarily black. So for people who were talking about colorism, there was also that part of the judgment that talk about, not talking about colorism, but see that we can see through the language used by the judges that colorism was also an issue. So I found that interesting, and I found also, and also the notion, and I'm sure that people will raise that the notion of what is public order. The way we construct public order in our society, and the way we exclude some people or some issue into the notion of public order. So I think that we have to be grateful to the courage of the grandfather and to the people of the United Church who support him to be able to go through that fight, because those fights are not easy fights. They have to be made to make sure that on trace la route, make sure that the path is open for the others. And today I think that your grandfather is looking at us and looking at what we have done with his path. And we have to thank him for that. Wherever he is, we have to thank him.
Well, I asked him about going to the Supreme Court, and he said, Terry, we didn't have very much money, and I would have never been able to do it. So the church and fundraising made this able to happen. Otherwise, like I said, we wouldn't be sitting here.
Yeah, but there was also his courage to go forward and go forward.
And that's the kind of man he was.
Yeah, and I think that we go back to the men. And I think that, whatever we discuss about color blindness or whatever, but I think that what is most important for him and for us is to go back to the notion of dignity. And I think that, that conference is about dignity. And the court did not give in at the time, but it's never too late. That's absolutely.
Associate Provost for Equity and Academic Policies. She's also a law professor in this faculty. She specializes in family, health, succession, and criminal law. Professor Campbell is a recipient of the John W. Durnford Award for Teaching Excellence, conferred by the Law Students Association. She's a graduate of McGill and Harvard Law School, and a former clerk to Justice Frank Yacobucci of the Supreme Court of Canada. I'll turn things over to Professor Angela Campbell.
Mr. Niemi, Madam Anthony, Imaki, and especially Professor Blackett, thank you so much for this opportunity to chair this panel. thank you to all of you for bringing us together this afternoon. I want to acknowledge in particular Tori Williams, who's not yet returned, but I'm sorry that she's not here, but I'm going to signal her work. I'm actually acknowledging you, Tori. In my role as Associate Provost, I have the honor and privilege of working with students like Tori who do remarkable work in terms of advancing equity, diversity, and inclusion on our campus, which is moving, but it can be a tall order. So thank you for your work, Tori. I also want to acknowledge in particular and say thank you to my colleague and friend, Adele Blackett, not only for this superb event, but also for incredible guidance and advice and support and gracious honesty in the work that we do on this campus as regards equity, diversity, and inclusion. So I will have the opportunity to say a few words about each of our speakers, and then I'll turn it over first, I believe, to Maître Landry. I'll begin by introducing Professor Adele Blackett, Advocate Emeritus, who's a Professor of Law and Canada Research Chair in Transnational Labour Law and Development at the Faculty of Law here at McGill, and a 2016 Pierre Elliott Trudeau Foundation Fellow. She holds a BA in History from Queen's University, Civil and Common Law degrees from McGill, and an LLM and JSC from Columbia University. She's also an elected member of the International Academy of Comparative Law. A former official of the International Labour Office in Geneva, Professor Blackett has been an ILO expert both on standard setting on decent work for domestic workers, leading to the adoption of the ILO Convention number 189 and Recommendation number 201, and in the Labour Law Reform process in Haiti. She was a Quebec Human Rights and Youth Rights Commissioner from 2009 to 2016, and in 2018 was appointed to the Human Rights Experts Panel on the Canadian Court Challenges Program and the Canada-European Union Trade Agreements roster of experts for dispute resolution under the Trade and Labour chapter. Professor Blackett has worked to bring a critical decolonial approach to the study of labour law in the Global South and as concerns the South of the North. She founded and directs the Labour Law and Development Research Laboratory and has guest edited or co-edited 5 special issues of journals and 2 books, including an open access AGIL Unbound Symposium on the Transnational Futures of International Law in 2019, a special issue of the Canadian Journal of Law and Society on Decolonizing Labour Law, Contributions to an Emergent Transnational Labour Law in 2018, a special issue of the Comparative Labour Law and Policy Journal on Labour Law and Development, Perspectives on Labour Regulation in Africa and the African Diaspora in 2011, and the Research Handbook on Transnational Labour Law, published in 2015 with Elgar, Press with Andrew Milko. Her recent monograph is Everyday Transgressions, Domestic Workers' Transnational Challenge to International Labour Law, published in 2019 with Cornell University Press. A member of the Law Society of Upper Canada and the Barreau du Québec, she was awarded the latter's Christie Award of Merit and the status of Advocate Emeritus in 2014 in recognition of her social commitment and her contributions to the advancement of women. In 2015, the Canadian Association of Black Lawyers awarded to Professor Blackett its Pathfinder Award for her significant contributions to the legal community and the community at large. Maître Marie-Claude Landry, avocat émérite, est présidente de la Commission canadienne des droits de la personne depuis sa nomination en mars 2015 pour un mandat de 7 ans. Jusqu'à cette date, elle était l'associée principale du cabinet d'avocats Landry-Boucher et associés qu'elle a cofondé. Forte de nombreuses distinctions et de sa notoriété, Madame Landry est une leader dans sa région des cantons de l'Est, au Québec, où elle a défendu l'offre de services et travaillé à l'amélioration des services de santé et de soins palliatifs. Elle a également travaillé à maintenir les services judiciaires, à dynamiser l'entrepreneuriat local et à favoriser un développement communautaire bénéfique. Digne d'intérêt, ses activités de sensibilisation, tant dans le domaine communautaire que dans le domaine du droit, lui ont valu de nombreuses nominations et reconnaissances, dont le titre d'avocat mérite du Barreau du Québec et le prix mérite du Barreau de Bedford. En 2015, la ville de Cowansville lui a remis les clés de la ville et la communauté de Beaune-les-Espoirs l'a nommée personnalité de l'année. Toujours soucieuse de placer la personne au cœur de ses actions, Mme Landry veut utiliser son leadership dans le domaine des droits de la personne pour continuer à protéger les gens en situation de vulnérabilité et à travailler avec les communautés de toutes les régions du Canada dans un esprit d'engagement et de collaboration. And last but certainly not least, Professor Brenda Narain is a professor at the Faculty of Law here at McGill University, where she's a beloved teacher and accomplished scholar. Professor Narain holds a BA and LLB from Delhi University in India and an LLM and DCL from McGill University. She has been a visiting research fellow at the Monk Institute for International Studies at the University of Toronto, and she has been a Bolton Fellow at McGill University, where she has also been a professor of law since 2008. Professor Narain's research and teaching focus on constitutional law, social diversity, and feminist legal theory. She is the author of 2 books, Reclaiming the Nation, Muslim Women and the Law in India, and Gender and Community, Muslim Women's Rights in India, both published with the University of Toronto Press. Professor Brenda Narain is the 2017 recipient of the Canadian Institute for the Administration of Justice's Charles D. Gontier Research Fellowship, and she was the Associate Dean Academic here at the Faculty of Law from 2016 to 2019. Thank you to the 3 of you for being here. I'll turn it over to McGill.
Alors bonjour tout le monde. C'est un honneur pour moi d'être ici parmi vous aujourd'hui. Thank you so much. It is an honor for me to be here with all of you today. Je voudrais vous remercier les organisateurs, les conférenciers invités, ainsi que tous les participants à cette table ronde. Je tiens aussi à remercier tout spécialement Tony Ely, une personne vraiment engagée pour l'égalité raciale au Canada. Before I go any further, I would like to respectfully acknowledge that the territory on which we are meeting today are the traditional unceded territory of the Haudenosaunee and Anishinaabe Nation. For me, acknowledging the traditional and ancestral lands is more than just words. It is one part of a larger effort toward reconciliation and toward better understanding. It is about acknowledging the long-standing relationship that Indigenous peoples have to this land and their contributions in the past, the present, and in our collective future. It is also important for me to acknowledge my own historical framework that I bring here today. That is to say that my perspective is that of a white person. I would like to begin my remark by sharing something that may surprise you. As a lawyer, as a human rights advocate, and with all my work in promoting equality, combating racism, serving as a national voice for human rights in Canada, and studying the impact of unconscious bias on our society, I must admit, Fred Christie's case was unfamiliar to me. I'm sure many people, many Canadians today, are also unfamiliar with Fred Christie's story. His story was not emphasis in the curriculum of the large majority of primary or secondary schools, nor in colleges or universities, including a large majority of law schools. De toute évidence, il y a un décalage entre l'histoire des personnes noires au Canada et ce que plusieurs considèrent comme l'histoire du Canada. Clearly, there is a disconnect between our country's Black history and what many understand to be Canadian history. Black history is Canada's history. L'histoire des personnes noires est partie intégrante de l'histoire du Canada. Nous connaissons tous l'adage selon lequel si l'on oublie le passé, on est condamné à le répéter. Quelle que soit la raison, quelles que soient les circonstances ou l'époque, la discrimination systémique cible et affecte les personnes de façon similaire. Que ce soit le refus de reconnaître la valeur d'une personne, son droit à l'humanité ou à la dignité, que ce soit d'isoler une personne, la priver de son emploi, de son logement, de son éducation ou de ses liens sociaux. Si nous ne saisissons pas l'occasion d'apprendre comment la discrimination s'est manifestée par le passé, nous risquons de ne pas comprendre comment elle se manifeste aujourd'hui lorsqu'elle se présente à nous. Connaître le passé permet de mieux comprendre le présent et de préparer l'avenir. Gardant ceci en tête, je voudrais partager 3 éléments clés qui m'ont interpellé à la lecture de l'affaire Fred Christie. Premièrement, les lois sont de puissants outils, mais elles ne sont pas infaillibles. The law is a powerful, but sometimes flawed tool. Deuxièmement, les lois ne suffisent pas à changer la société. Ce changement doit venir des personnes qui la composent. Laws alone do not change culture, people do. Troisièmement, personne ne peut y arriver seul. No one can do it alone. Ce qui m'amène à mon premier point, à savoir que les lois sont de puissants outils, mais qu'elles ne sont pas infaillibles. J'ai lu la décision rendue par la Cour suprême du Canada dans l'affaire Christie en 1939. Il est difficile de concevoir que la Cour suprême du Canada n'ait pas saisi les répercussions, la portée et l'impact systémique de sa décision. Comment le plus haut tribunal du Canada a-t-il pu placer la liberté de commerce avant le droit d'une personne d'être traitée équitablement? Carol Hayward, spécialiste en matière de racisme, est celle qui décrit le mieux les conséquences de cette décision. If you could pinpoint the exact moment in legal history when the courts were most supportive of and responsible for the perpetration of racist ideology in Canada, it would be the moment when the Supreme Court handed down the Christie decision. Il est encourageant de constater que les décisions plus récentes des tribunaux dans les dossiers de discrimination raciale ont reconnu que le racisme envers les personnes noires peut être complexe, subtil et souvent inconscient. Les décisions dans les affaires El Mardi, ou Wickham, ou Bassi n'en sont que des exemples. Dans sa décision de 1988 portant sur l'affaire Bassi, le Tribunal canadien des droits de la personne a déclaré que l'odeur subtile du racisme est rarement exprimée ouvertement. L'accès réduit à des opportunités d'emploi, aux soins de santé ainsi que le profilage racial dans les interventions policières résulte de la présence de ce qu'on appelle l'odeur subtile de racisme. La présence encore aujourd'hui de l'odeur subtile de racisme peut être constatée dans les données démographiques de la population carcérale du Canada et les données démographiques des personnes itinérantes. Ceci nous montre que, bien que le Canada a fait beaucoup de chemin depuis cette affaire, le racisme envers les personnes noires existe toujours, ici comme ailleurs. Nous devons rester conscients que la loi est un instrument utilisé par des personnes et comme nous le savons, l'erreur est humaine et l'humain est empreint de subjectivité. Les lois sont interprétées par ceux et celles chargés de les appliquer avec une perspective humaine, perspective sujette aux préjugés inconscients. L'application des lois au Canada, comme ailleurs, est le reflet de l'environnement dans lequel elles sont appliquées. Même en apparence neutre, nos cadres juridiques peuvent créer des obstacles et contribuer à la discrimination systémique. Nous devons être attentifs aux conséquences et aux impacts de nos propres préjugés sur notre travail et les personnes que nous servons. This brings me to my second point. Laws alone do not change culture. People do. Transformation comes through conversation, through scholarship, through intervention. The road to transformation is long, but it comes through persistence, through self-awareness, and through ongoing education. But transformation does not come easily. Every time we challenge racism, whether in our home, in our workplaces, in the media, or before the courts, we get one step closer to an equal society. Every time we realize that a certain rule, policy, or practice is skewed by harmful biases or assumptions, it is an important step forward for our society and for ourselves. Meaningful culture change requires that everyone acknowledge that racism encompasses a multifaceted system. It is very possible that the judges who decided on Fred Christie's case in 1939 were not, at that time, conscious of the impact of their decision. Even today, it is often challenging to become aware of our unconscious biases and the ways in which our words and actions can perpetrate systemic discrimination. Some people would like to imagine that racism is that a thing of the past. And even though it may be uncomfortable to admit it, it still very much exists, and we must talk about it. consider this. Study after study show and continue to show that racialized people must still overcome major obstacles to progress in their careers. Racialized lawyers are no exception. In order to dismantle anti-black racism, in particular in our judicial system and in society, we must recognize the critical importance of representation. Representation matters. Culture change will only happen when everyone is represented equally in our judicial system. When the people working at every level in the system accurately reflect the Canadian public they serve, especially at senior levels. Comme l'a déjà exprimé la juge en chef Beverly McLaughlin, les Canadiens devraient pouvoir se reconnaître au sein de la magistrature. Elle a souligné l'importance d'avoir une magistrature diversifiée afin que différentes perspectives puissent être représentées. Aujourd'hui, la Cour suprême du Canada ne comporte que des personnes de la branche. Or, les décisions de nos tribunaux et de nos cours de justice ne peuvent être aussi justes et éclairées que les perspectives et l'expérience humaine qui les accompagnent et qui les informent. Cependant, l'amélioration de la représentativité ne suffit pas. Il est essentiel d'être attentif et de comprendre les préjugés inconscients et leur impact. It affects all of us. No one is immune. Dr. Rachel Zeller, a scholar of racial bias, put it this way: if you have a brain, you have bias. That is why, at the Commission, we are working to understand our own biases. Through ongoing training and ongoing dialogue, we are constantly looking at our work through a critical lens. We consider the broader context in the racial discrimination cases that come before us. We do this to make sure we don't overlook what the basic decision calls the subtle sin of racism. We often say that clear understanding of the need to act is the best way to determine what actions we need to take. This way of working that we have adopted, all the training we have received, have made me more aware of my own biases. I have to question whether, as a mother of a daughter of Mexican heritage and a grandmother to her 8 years old black grandson, does my family experience cause me to think that I am immune to bias? This is something that author Robin DiAngelo describes in her book White Fragility like this. I believe that white progressives cause the most daily damage to people of color. I define white progressive as any white person who thinks he or she is not racist or is less racist. White progressives can be the most difficult for people of color because, to the degree that we think we have a right, we will put our energy into making sure that others see us as having a right. None of our energy will go into what we need to be doing for the rest of our lives, engaging in an ongoing self-awareness, continuing education, relationship building, and actual anti-racist practice. White progressives do indeed uphold and perpetuate racism, but our defensiveness and certitude make it virtually impossible to explain to us how we do so. The danger lies in our unconscious bias going undetected, unchecked, and unchallenged. Increasingly, racism and other forms of systemic discrimination are viewed as a complex web of cultural norms. While this complex web can be seen in individual and explicit acts of discrimination, in other words, while it can present itself in an accurate way, racism is not acute. I repeat, racism is a structure, not an event. This complex web can cause insidious harm to people's rights to justice, to education, to medical care, to housing, and other essential areas of life. Increasing our awareness of this complex for each of us, everyone in Canada, in particular those in decision-making roles, to engage in a self-awareness in a sustained and ongoing way in order to understand our own biases and encourage others to do the same. Ce qui m'amène à mon dernier point. Lorsque Fred Christie a préparé sa défense, toute sa communauté s'est mobilisée pour le soutenir, notamment en amassant des fonds dont il avait besoin, que ce soit le Bavry, le syndicat des porteurs de bagages des services ferroviaires ou l'Église Union, ici même au Montréal. Personne ne peut y arriver seul. Nous devons agir de concert avec d'autres pour faire changer les choses. Les choses évoluent que par la force du nombre. Au Canada, trop de gens prennent leurs droits pour acquis. Nous devons saisir toutes les occasions d'honorer ceux et celles qui, avant nous, ont fait des sacrifices pour faire progresser les droits de la personne. Nous devons agir, faire pression, lutter pour une société au sein de laquelle tous se sentiront inclus, valorisés et en sécurité. Nous ne devons pas rester silencieux. Le silence nous rend complices. We cannot stay silent. Silence makes us complicit. Combattre le racisme et les inégalités raciales sous toutes ses formes est une priorité pour la Commission et pour moi-même. En conclusion, j'aimerais vous partager cette réflexion. J'ai entendu récemment que l'affaire Fred Christie ne s'est jamais J'ai entendu récemment que Fred Christie lui-même ne s'est jamais considéré comme un défenseur, comme un activiste. Pourtant, aux yeux de sa petite fille, c'est ce qu'il était. Elle a dit qu'il nous a toujours poussés à faire ce qui était juste. On se tient debout pour ce que l'on pense être juste. L'histoire de Fred Christie ne m'était pas familière. I was not familiar with Fred Christie's story before. But I am now. And I'll make sure that my children and my grandchildren are too. And I will use my voice to spread this message far and wide. How about you? Thank you, everyone. I look forward to our
Good afternoon, everyone. Thanks for sharing your Saturday afternoon with all of us. Before I start, I'd like to thank the panelists who came before me. I learned a lot from Professor Walker and also from Mr. Brazil. So thank you, and thank you as well to Mr. Landry. The topic that I gave my presentation is legislating difference. So, in his book, The Souls of Black Folk, W.E.B. Du Bois asks, how does it feel to be a problem? That same question can today also be asked of Muslim women in Quebec. In June 2019, Bill 21, an act respecting the laicity of the state, imposed a ban on religious symbols in the public sphere when giving or receiving services, including municipal services such as public transit, doctors, dentists, and midwives in public institutions, subsidized daycares, and school boards. It was justified on the basis of preserving the separation of state and religions, the religious neutrality of the state, the equality of all citizens, and freedom of conscience and freedom of religion. In effect, among other things, Bill 21 prohibits those wearing religious garb that covers the face from either giving or receiving public services. And of course, this law would disproportionately impact Muslim women of faith. So Canada's religious landscape is constantly transforming and becoming more diverse. Reasonable accommodation and its accompanying discourse represent the framework within which the state accommodates minority differences and establishes the extent to which the state ought to permit minority cultural and religious practices in the public sphere. Reflecting the public discourse regarding the anxiety about religious minorities in liberal practices, and particularly the hypervisibility of Islamic difference, successive provincial governments have tabled bills regulating the presence of religion in public spaces. And these legislative efforts have punctuated provincial politics, and they provide a useful prism to analyze law's role in responding to popular anxieties and in shaping the perception of difference. So in the time that I have today, rather than going into the details of this law, I'm going to confine my remarks to offering an analysis of Bill 21 and of the framework of reasonable accommodation. So what I suggest to you is that Bill 21, rather than responding to a gap or legal gap, serves a political purpose. It demonstrates a populist response to anti-immigrant sentiment and widespread anxiety about the place of Muslim immigrants in Quebec. Similar to previous legislative initiatives, Bill 21 identifies principles of secularism and religious neutrality as its justification, and once again raises the red herring of gender equality, pandering to stereotypes of the oppressed Muslim woman. Bill 21 doesn't further inclusion, equality, or democratic citizenship. On the contrary, it further stigmatizes and marginalizes Muslim women who are portrayed as in need of saving and rescue from their own communities and from their own religious beliefs, which are seen to impede communication and participation in the body politic. This misunderstanding by mainstream society that they are forwarding the cause of gender equality and inclusiveness by supporting legislative restrictions neither empowers minority women nor recognizes their agency. On the contrary, it reinforces state control and reinforces the victim narrative. And this picks up with some of the things that Professor Walker mentioned in his presentation earlier today. Bill 21 is an example of how state secularism and neutrality are used to limit rights. And these concepts have been pivotal to the construction of a self-conscious nationalist, a cultural nationalist identity. And racialized minorities, particularly Muslim women, are then seen as the unassimilable citizen, cast out until they do assimilate. They are illegitimate citizens in this respect. It sets up women's rights as opposition to culture and identity. It doesn't consider the effects of the bill on Muslim women whose mobility, health, and educational opportunities will all be affected. Instead, it focuses on the intolerability of a religious practice to the majority and what it symbolizes to the majority. In the time that I have left, I want to quickly pass to a few remarks on the framework of reasonable accommodation. And Angela, you cut me off ruthlessly. 10 minutes. So reasonable accommodation, just really simply, is the framework through which the state accommodates minority rights and balances or reconciles competing interests. And my suggestion to you is that state policy towards minorities and the reasonable accommodation discourse reinforce the racial status quo by setting the terms of the debate and the limits of tolerance. In other words, both of these set the epistemic conditions that dissuade a close scrutiny of the way in which the state manages diversity. So religious difference is seen as something the state has to intervene in, to manage. It communicates the existence of problematic social behavior that renders necessary state regulation. So reasonable accommodation is seen commonly to be about religion and secularism, not race. And race is effectively erased from the debate. And we all know that race is embedded in this contested terrain of reasonable accommodation, and yet the debate has been cast as largely racist. It works in effect to exclude racialized others from the national family while reinforcing its legitimacy as such. Reasonable accommodation discourse is embedded in the governmentality of equity and diversity policies. It tokenizes minority groups rather than demonstrating the political will to engage minorities or to challenge institutionalized racism. I want to turn now to community responsibility because that's a big piece of, I think, what we need to think about. Turning to the responsibility of communities themselves, it's important, I believe, to acknowledge the complex location of minority women along multiple axes of discrimination and the reality of oppressive patriarchal customs which impact their response to discrimination within their own communities as well as to gendered, racialized state systems of discrimination. So the state's response can't just be increased legislative regulation. It must focus on inclusion and democratic participation. The construction of Muslim women as victims without agency complicates their own challenge to gender disadvantage within the community. Community leaders who are invariably men discourage women from critically examining inequalities within the community in order to maintain group solidarity in the face of mainstream hostility. So as a result, women within minority communities find it very difficult to sustain a progressive politics for fear of feeding into a racist or an anti-Muslim agenda. So what happens? Is it just a picture of doom and gloom? And I have a few thoughts about that. So this last bit is called Moving Forward. What we've seen is that in public discourse, reasonable accommodation has come to be understood as synonymous with the accommodation of religious diversity. What it does is obfuscate issues of structural inequality, institutionalized racism, and the structure of difference. It reifies the debate into us versus them binary. And what I suggest to you is that unless we insert race into the analysis, it will remain little more than a way to sustain the racial status quo, and power hierarchies will remain intact. The reasonable accommodation framework is an integral part of the state's response to difference, yet the legitimizing function of inequality that it sustains has not been adequately interrogated. The framework of reasonable accommodation fails to redistribute social, economic, and political power to minorities. Such top-down practices of governmentality must be rejected in favor of an intersectional, anti-racist framework and policy that looks to crafting remedies and institutional responses from the ground up, from the daily experiences of those at the intersections of discrimination, to create radical social justice tools that challenge racial injustice. An intersection framing of the experience of minority women that is attentive to power relationships offers the possibility of a counter-hegemonic political project that is linked with struggle. And I'm insisting here on the link with struggle. It is important to connect this effort with the everyday struggles of racialized women and indeed the accommodations that do go on in everyday life. It is necessary to counter dominant readings of reasonable accommodation, moving the focus away from whether or not minority religious practices should be accommodated, to an analysis of the debate on this issue, how the terms of the debate construct racialized women, how links are drawn between national belonging and proper subjects of citizenship along racialized lines, and the way in which cultural signifiers are used as a racializing code. We need to avoid an all-or-nothing choice for women between cultural autonomy on the one hand and access to education, employment, political participation on the other. Focusing on the redistribution of social, economic, and political power to exclude groups, policy around minority rights and reasonable accommodation must be reconceptualized as a frankly anti-racist policy that challenges culturalism currently faced by minorities. Seeing minority groups primarily in terms of an essentialized culture pays inadequate attention to issues of structural disadvantage and systemic racism. This culturalization of politics has permitted liberal democracies to initiate legislation such as Bill 21 that leaves unexamined the roots of oppression, resulting in further economic disempowerment and political disenfranchisement. The focus on culture has de-radicalized anti-racist politics. It has erased race. The uncritical conception of culture and diversity and its co-option by the rhetoric of reasonable accommodation has dematerialized the understanding of culture, making it a political tool while rendering the language of diversity a tool of governance, rather than a demonstration of the state's commitment to challenge inequalities. For reasonable accommodation to respond to cultural difference without challenging systemic inequalities is inadequate in fighting the roots of oppression, racism, and discrimination. Difference cannot be characterized simplistically as a cultural category uninflected by relations of power, and cannot be constructed as separate from structural inequality. The discourse of diversity and reasonable accommodation has to be reframed, and until then, Muslim women will continue to be seen as problems for the national democratic secular consensus. Thank you.
Donc, il me fait un énorme plaisir de vous adresser aujourd'hui et je tiens aussi à remercier toutes les intervenants précédents pour leurs commentaires vraiment émouvants et judicieux. Today I will be covering 3 points linked to the Christie case and where we go from here. The first, which reflects the framing of this symposium, is that Christie is not just a case about the past. And as others have argued, including today, we do a disservice to treat it as legal history. Christie and York's long life in law in Canada underscores the persistence of a legal indeterminacy and the ongoing challenge of naming deeper structural concerns. So we know of the advent of the legislative recognition of fundamental human rights through our constitutional charter and through quasi-constitutional legislation, human rights codes, and in Quebec, the Quebec Charter of Human Rights and Freedoms. We know of the institutions put in place with tremendous powers of investigation, reporting, education, monitoring, litigating. For 7 years, I had the privilege of observing this as a commissioner from the inside, and yet do not tell a contemporary story of triumph. Often people speak of the move to more subtle forms of discrimination, but in this moment, we see a resurgence of white supremacy, of emboldened, blatant forms of discrimination, and of growing obstacles through the manner in which human rights law is interpreted. Think in particular about the way in which racial profiling is being addressed post the Supreme Court of Canada's Bombardier decision. Think about the startling overrepresentation of communities, of the young people in Montreal, the young Black men who are stopped over and over and over so that it feels normal. So even the framing that with our charters, racism has become more subtle needs to be rethought as a starting point. But we are in Canada. We remain capable of enforcing an ever spatially entrenched divide politely. Politeness comes through the Christie case. He wasn't humiliated because he was refused a drink politely. Remember that the Black community around Little Burgundy that was soon to move more decisively into Verdun
where Mr. Christie lived, was, and this is sometimes surprising, relatively more prosperous relative to other members of society than the staggering statistics, some of which have been read today, suggest now. So there is a level at which we have not engaged with what emerges, both through Justice Galipeau's dissent at the Court of King's Bench at the time, reminding us that it is the old logic, a 19th century logic privileging doctrines of freedom of commerce over public law reasoning that was applied not of necessity but by choice, a point addressed subsequent to the Supreme Court decision by Borolaskin, then a law professor, later Chief Justice of the Supreme Court, and by our own F.R. Scott, who ultimately emphasized in his critique of the case that the judges of the Supreme Court of Canada even then had a choice, and I quote, "In choosing the particular result in this case, the majority of the judges exercised a discretion that could well have gone the other way," end of quote. Recall how readily the first decision, the 1936 Superior Court decision in Christie, rendered a clear and unequivocal affirmation of non-discrimination, only to be told on appeal that it should be parsed with the shopkeeper's general right of commerce. And recall even more that Justice Bousset of the Superior Court, in a theater segregation case, Johnson v. Sparrow from 1899, had the following to state, and I quote, "It would perhaps be trite, not trite, right, to speak of slavery in this connection, and yet the regulation in question is undoubtedly a survival of prejudices created from the system of slavery. He acknowledged slavery's existence in Canada. He traced its gradual extinguishment in Upper Canada and the province of Quebec, adding that, and I quote again, our Constitution is and always has been essentially democratic. It does not admit of discriminating distinctions of races or classes. All men are equal before the law and each has equal rights as a member of the community," end of quote, before turning to the legendary Somerset and Stewart case from 1772, in which Lord Mansfield famously declared that, quote, "every man who comes into England is entitled to the protection of English law," end of quote, whatever oppression he may heretofore have suffered and whatever may be the color of his skin. The Court of King's Bench, in upholding the decision of the Superior Court, narrowed it to the question of whether a contract had actually been formed in the Johnson v. Sparrow case. And Justice Galipeau in Christie relies heavily on both decisions to formulate his assessment. So the analytical framework that instead treats the freedom of commerce as a fundamental starting point is challenged in the work of legal scholars emerging out of a legal realist tradition and out of a critical legal studies tradition. But it persists today. And it's seen in other disciplines, including my own, in labor relations, in which modern labor law frameworks, like modern human rights frameworks, can still find vestiges, acknowledgments that despite regulatory action on fundamental rights, a property owner may choose how to run his business and choose to go out of business if necessary, rather than adhere. So the framework and the approaches that address these fundamental, foundational understandings of the relationship between 19th century conceptions of property are central to a rethinking, and I believe this is where my colleague Barrington Walker was taking us with his analysis as well. A critical race theory approach sits in kinship, therefore, with approaches through critical indigenous studies and analyses of slavery through a racial capitalism lens. They offer an increasingly urgent call to think about the work that frames legal liberalism, the work that legal liberalism does in framing particular kinds of relationships of subordination, deeply asymmetrical, the work that it does in enabling white supremacy to be perpetuated through freedom of commerce, in enabling colonial relations to remain ongoing. A clear-eyed engagement with why we need to hold on to a politic of recognition, something that we know that Mr. Christie understood, something that we can witness, frankly, through the transcript of the Superior Court decision as he was cross-examined. Mr. Christie, are you really black? You are so light-skinned, so polite, you might pass if you did not identify, if you did not refuse to assimilate, if you did not refuse. To which Mr. Christie insisted in that transcript, I am black. If we do not pay attention to how legal liberalism emerged and becomes intelligible through a global institution predicated on unfreedom, the centuries-long transatlantic slave trade, then we will perpetually miss how it continues to build upon racial dichotomies, how it continues to draw upon and consolidate racialized power precisely through rather than despite the law. We will continue to relive the past. So we need alternative ways of knowing law. We need ways to move us beyond parsing the distinction between, as in Christie, a tavern and a restaurant, missing the dehumanization at work in the denial of Mr. Christie's inherent dignity. We need sources that take us beyond the comfort of the neatly reasoned case that entirely misses the point. Do we teach Gregson and Gilbert and contend with the same Lord Mansfield, whose judicial neutrality in Gregson was so important, his tightly parsed legal analysis of why ship owners who threw cargo of enslaved, sickly but living Africans into the Atlantic, knowing they would be worth more in insurance money than alive? Or do we read N. Phillips' breathtaking exploration of legal poetry, knowing the Zal massacre was not the time for tight, careful legal reasoning, but a time to decide on the basis of human dignity, a time to step outside of the familiar form and scream its irrationality. Norby's Philip affirms there is no telling this story, it must be told. To take cases like Christie and York seriously, very seriously, in the contemporary context of resurgent exclusion, is to engage deeply with how we understand societal transformation through, and in many ways beyond, Cartesian legal reasoning, keeping in focus what social justice demands. My second point builds on that theme because it underscores, as many have today, how social justice has been achieved through communities that have understood the need to stand up, understood the need to resist. The Christie case is a reminder that law lives in communities it is challenged in and by those communities. Christie in Europe, like Zong, like Dred Scott in the United States, spurred on successful public and political mobilization for emancipation. The Christie Defense Committee adopted the slogan, "Protect yourself against racial discrimination." And Dr. Melville, who was asked to join the committee that was formed in and through Union United Church. And I want to reiterate the words of Ms. Irene Anthony through Reverend Dr. Est, who built community through and around Union United Church and the Negro Community Center that was formed. That Dr. Melville was asked to join to help raise the $1,000 for the appeal and came on board as what I will refer to moving forward, part of an acknowledgement and recognition of what Vincent Harding, a fellow traveler of the Reverend Dr. Martin Luther King Jr., referred to as the vocation of the Black scholar. I think we need, therefore, to be deeply attentive to the démarche on behalf of community, to make sure that in challenges to racial discrimination, challenges to dehumanization, that we're working with and through community. Vincent Harding wrote the following: "Surface manifestations are never the best indication of the movement of the Black community, where critical repositioning is now taking place." And he wrote this in 1974, soon after founding an Institute for the Black World, soon after, as part of his response in the wake of Dr. King's assassination. For Harding, Black scholars in search of vocation needed to look beyond the affluent walls of the university to the social, political, and spiritual context of the condition of the Black community. That, and I quote, "the ties that bind us, or that transform the radical nature of our people's position." There may be moments in our own community now when we need to pull together, when we need to see the bigger picture, when we need to see why we cannot leave members of our community to struggle for equality rights alone. So I'm calling for us to think deeply about the ways in which we can build solidarity and sustain thicker forms of resistance in the interest of our community as a whole. My third message speaks very specifically to McGill and to the bicentenary. As McGill commemorates 200 years starting this fall, we enter a pivotal moment also for the Black community of Montreal. McGill's history, as I alluded to at the outset, is part of the history of the Black community in Canada, and it embodies all of the contradictions and challenges. As someone who was born and raised in a working class immigrant family in the Montreal Black community, I know McGill at times seems more remote to members of communities that are deeply underrepresented here than many of us really recognize. It is easy for universities to lose sight of how the community sees us, the historical memories that community members may carry about place and space and time. One such memory was shared with me by the venerable late Dr. Leo W. Berkeley, also a graduate of McGill. He spoke of the letter that he held refusing a Black applicant admission to medical school on the basis of race. I never saw that letter. What I have seen, what I have lived, is the sense that there is a distance that can be so hard to overcome without proactive means. That includes engaging thoughtfully and carefully in a community-rooted manner with our past and with our present. Institutions, sister institutions like Dalhousie, have offered recently sparkling, powerful examples of how to address carefully at the highest levels and with community involvement the history that is shared, the history of slavery, the history of anti-Black racism that was part of the centuries-long institution of slavery and its afterlife. The report released last year by a task force that was chaired by Professor Afua Cooper, leading historian, and included a range of community members and legal experts, is comprehensive and carefully researched. And resources were put behind ensuring that a researcher at the highest level could be given the space and time to chair the committee that engaged graduate and postdoctoral fellows, but was community-led and focused. It builds on similar initiatives undertaken in several leading US schools. It's a critical example of what can be done when community is folded into an initiative in a meaningful way. I wish to acknowledge the tremendous dedication, the hard work that has gone into making it even possible to address what our community here at McGill knows is part of our history. And I wish in particular to acknowledge the tremendous devotion of my colleague, Professor Angela Campbell, on these issues. And so what I say as part of a commitment in Vincent Harding's tradition to speaking truth to community, and that is that we here at McGill need a comparable initiative. Our communities must be centered in the reclaiming, not only of what our past is and what our relationship is to now, but the how and the who. Vincent Harding understood the vocation of the Black scholar as that of speaking the truth to the people, and he affirmed that our truest vocation will seek us. This is a pivotal moment in Montreal Black community, to think about where we are as a community as we commemorate how those who came before us, epitomized by Mr. Christie's struggle, insisted on sustaining their integrity, their quiet but steely dignity, their wholeness. And thank you very much, Mr. Brazil, for insisting on that wholeness. To work for community, to reclaim the truth of our past, and to construct the truth of here and now. This is something we must claim and define on our own terms. We must not abdicate the vocation of truth-seeking and truth-speaking out of love for our communities, including our university community that we inhabit.
Thank you. Thank you to all of the panelists. So we have a little under 10 minutes for questions and discussion, and so I'll open the floor. Please.
Thank you very much for the presentation. I'm a school trustee here in Montreal, and I'm a school trustee here in Montreal, and it was under my committee at the English School Board that we brought a lawsuit against Bill 21. But here's the parallel that I see. When I look at the Christie case, what's very interesting to me is that the servers were ordered, presumably it's very interesting that you say that when you talk about, we're no longer talking about race, we're talking about culture. But given that these laws are demanding that our institutions or businesses discriminate, how do we get back to that discussion about race when we're now talking about culture and language? How do we get back to talk about race, which is really what we want to focus on?
Any other questions for me?
For anyone who wants to answer.
Should I answer? I think that's an excellent question, and I think that it is the way in which culture has been magnified, right, rather than race, because it's an unwillingness to talk about race, and it becomes easier in this kind of a liberal pluralist democracy to think that we're accommodating culture, right? So I think that part of the challenge is to bring race back into the analysis. And how we do that is then to have a kind of a more democratic politics, to have a more inclusive, participatory politics. So it has to start at the ground up. And I think that part of the problem is that we're looking too much to the state. I think we need to be looking at civil society, the non-formal public sphere. How do we engage with each other? How do we build coalitions across issues and not on the basis of identity? So it's a big question, and I think but it's part of the struggle.
Yeah, definitely. Quickly, my comment, I just want to touch on three things. Deal with racial profiling, because that's one of the things that the first speaker talked about. I believe that the racial profiling would be bad. Racial profiling and these kind of things would be falling on public opinion. On the ground, what I'm seeing is that the courts and the administrative bodies that are sort of designed to fight and combat rights and racial profiling are ill-equipped and often unwilling to even deal with the issue of race as a concept to begin with, find ways around that. So that's first and foremost. What we see, or what we saw in Fred Christie, Professor Blackett highlighted this point is the fact that the community is really the one that brought this case forward all the way to the Supreme Court. Without the black community, as I mentioned earlier, we wouldn't even be here. But we don't see that today. On the ground, we don't see that today. Black community, in my opinion, is not willing to take on these very sensitive race issues and to come to support cases that are victims. And again, I'm talking about victims struggle. So what I like about racial profiling, and that's I want to end my comment and I'll ask a question specific to this issue, is the fact that racial profiling really does not discriminate. It's beautiful. Racial profiling does not discriminate because whether you're black, dark skinned, light skinned, poor, rich, even if you've got a law degree, or if you're a lawyer, a doctor, you're old, you're young, you're a potential victim. You just get out there. Some folks have this notion that I've got it made. It won't affect me. Well, we see that on the ground every day, and it doesn't matter. And I think that public opinion, both in the white community and the black community, is the only way that will make the needle move with respect to dealing with the issue. Because some folks feel that they're immune from racial profiling, and they're not. So the question to the CHR and also the universities as a whole is what can you do to change that public opinion within university walls and within the CHR that you have? I mean, we talk the same language and everything else. But once you get out there in the community and you try to convince folks that you know what, racial profiling actually really exists. So what can you do as institutions to change that public opinion and narrative?
Yeah, I think that it's a very good question, and thank you for your question. First, I will agree with you that I think that the organizations are not well equipped to deal with this, and we need to, again, be conscious of that, and we need to first have a look at our
organization, we're saying that, okay, we give one training to our staff, done, it's over. It's not about that. It's about knowing that it's something that we should constantly do. And also, I think that racial profiling and racism it's not something that just one organization will result. I think that it will take a concerted effort amongst all groups. Should be the Quebec Commission, the Canadian Human Rights Commission, working with the Black Federal Caucus, working with many groups, and try to deliver the same message. That it's something that we need to address. And racism, I think that one of the dangers, I really believe that people think that we are there. Racism does not exist anymore. It was in the past, and it's not in 2020 something that people experience. And this is where it's wrong. It's like thinking that the women who face challenges today, it's a thing of the past. It's not true, and we need to address it. We need to continue education. We need to speak out about that. As I mentioned, I strongly believe that we cannot remain silent. Silence makes us complicit of what's going on actually.
So we'll just, there's exactly. Actually, no, there was a hand first, and we're very short on time. So I'm going to ask you to frame your question in less than a minute, and the response is the same.
The minute extra.
No, it's not. I'm going to take this gentleman's first, actually, because his hand was raised a long time ago. Please.
Thank you to Fo and Dakar for bringing this case back to the surface. In the province of Quebec, we have difficulty naming racial discrimination, and that's one of the points in history where we can do it. We found ourselves without a charter at that time in 1940 when the Supreme Court came down with the decision. We find ourselves with a federal and a provincial charter now. As Professor Narain has noted, sort of Bill 21 talks around issues of race. And unfortunately, under the Quebec and federal charters, there's a way to get around those discussions. It's called the notwithstanding clause. And those have been acted in that piece of legislation. There might be another way to look at it. If we look at another case that grew out of Montreal, the case dealing with Roncorelli and Duplessis, they spoke about an improper purpose, right? In administrative law in Quebec, the notion of an improper purpose is something that goes beyond a simple rights analysis. Right? If we were to look at this, and we've got a gentleman who's over there, a trustee of an English language school board, maybe you have an argument that other people don't have. Minority language rights are protected in the province, and there's no notwithstanding clause that can apply to the arguments that you have standing to make. If there is an improper purpose, and it relates to the larger legislation, what goes unsaid, maybe there's a way to take a look at this question from a different light with some reframing. That's my minute.
Thank you. I'm going to take that as a comment.
Yes.
Thank you again to all. Do you like it?
Please join me in thanking Matt Conley and my three extraordinary colleagues. Now I have the pleasure of Mr. Mark Henry, President of the Jamaica Association of Montreal, has a brief word for us. Henry.
Bonjour tout le monde, good afternoon everyone. On behalf of the Board of Directors and members of the Jamaica Association, I'd like to thank the McGill faculty of law and for naming to the core group who are great advocates for our community. Just very briefly, in 1 minute or so, I really want to speak to the spirit of Fred Christie. That spirit that can be traced back to his Jamaican heritage. And I often know that Fred came at the age of 17 years old as an immigrant, looking for a better opportunity, like many of us Jamaican Canadians, looking for a better opportunity. Coming here myself at the age of 16, empathize definitely with that. And as I sat there and sort of went through the whole process, I noticed that his point of frustration, a new culture, away from his love, his immediate family, just a totally different environment. The hypocrisy of the whole thing, having ordered the same case before, and suddenly at a big event, it was no longer welcome to take an order, that point of frustration. But the big point is, while many, when we think Jamaica, we think of the beautiful land, the sun, just a great place. But the Jamaican history is one of a fighter, where a strong culture fight, one of the first Caribbean countries that gained over independence. And so, as Jamaican Canadians, we've made a great impact in this country, and we'll continue to make a great impact in this country with hard work and fight. And just want to say thank you to Fred Christie for that fight. Have a good evening.
So the only word between us and the cocktail actually is going to come from Mr. Peter Clagle. Clagle is the Director of the Government of Canada's Anti-Racism Secretariat, which is the cornerstone of building a foundation for change, Canada's anti-racism strategy 2019-22. In addition to coordinating federal action and driving the overall strategy, he's responsible for working with federal departments and agencies to identify and coordinate initiatives, identify gaps, and consider the impacts of new and existing policies, services, and programs for communities and Indigenous peoples. He draws on a long history of leadership in the government, NGO, and philanthropic sector. Mr. Peter Clagle.
Thank you very much for giving me this daunting opportunity first to be that which separates you from the tasty cocktails that are waiting you inside. And it's also very daunting for me to speak after such a dazzling constellation of speakers. So I will try to do my best to contribute to what seems to have been a very fruitful and enlightening conversation today. Je voudrais tout d'abord commencer en remerciant les organisateurs pour avoir eu le courage et le mérite d'organiser ce symposium aujourd'hui. Notamment, je pense à la professeure Adele Blackett, que je connais très bien, merci pour l'invitation. But also, obviously, like to salute. But also, I don't know if it's been said, but mentioned that it's Phonian's birthday today. And the Jamaica Association, but also I'd like to salute and thank, I guess, the coalition of organizations, some of whom are represented here today, who really were kind of the spearheading behind all this critical work around raising awareness about this, the Fred Christie case. So please give them a nice and warm round. So as I stand before you in your midst today, at my alma mater, I should mention, I cannot help but see conjured up to my mind the intense organizing, the intense planning, and the intense strategizing which occurred 80 years ago here at McGill, and which was the fundamental, I guess, piece of the axis of resistance that connected McGill University to Union United Church and to Montreal Civil Society more broadly, in order to, I guess, propel Fred Christie into the case that is recognized by few of us in Canada here today. I say that because I too have been nourished by that axis of resistance as I went to McGill University and was also a member of Union United Church, and I can remember many intense hours strategizing, planning, and organizing to address different forms of systemic racism, anti-black racism, and other forms of oppression today. And so it's great to see coming back today, I think, about 20 years later, to see that that same energy and commitment is still alive as there are members of the McGill community and Union United Church and broader civil society gathered today. At the Anti-Racism Secretariat, I think we've been reflecting on what the significance of the Fred Christie is, what it means to us at the federal level, as we are responsible for coordinating a whole of government approach to combating racism, systemic racism, and hate in Canada. And during our conversations, we've asked ourselves what kind of distinguishes Fred Christie from some other perhaps lesser known change makers that have also kind of taken a stand against racism, racial discrimination, and other forms of hatred that have existed and continue to exist here in Canada. And I think for us, what stands out is the systemic dimension, because it was not simply a story of a man standing up to racism. It's also a story of the highest court of our land, the Supreme Court of Canada, legalizing giving the constitutional stamp to racial segregation in Canada. Because before that moment, as many of you mentioned today, racial segregation was a fact, a de facto fact of Canada, based on norms and general practices which were not consistent. But with the decision of the Supreme Court, it essentially enabled racial segregation to be constitutional, to be legal. And in Quebec until 1975, when the onset of la Charte des droits et libertés du Québec, which was introduced 7 years before the repatriation of our Canadian charter, and which actually, if we take the time to read the charter, goes several steps further than the federal charter in recognizing and looking at and preventing, or combating, I should say, racism in the private sphere. And so it's really that institutional systemic piece, which is a particular concern and interest to us as the Secretariat, because our mandate is grounded in what's called Canada's anti-racism strategy. So over the past 3 years, the Government of Canada held, I think, over 22 consultations and conversation engagement sessions with communities to understand what it should do to combat racism and racial discrimination, systemic racism in the midst. So right there was more than a tacit acknowledgement that racism exists. There was an overt acceptance that racism exists and that the federal government has a fundamental role to play in removing it. So what ended up happening following those engagement sessions was that the Department of Canadian Heritage compiled the recommendations, and from there was drafted Canada's anti-racism strategy, which is a 3-year strategy, which if you, like google.com, you can look it up if you haven't already, which really lays out a foundation for more federal action to combat racism and racial discrimination in Canada. And so what's key to that strategy is recognition that racism is not simply a matter of individual relations. If you saw or read the very recent Environics Institute study, or survey, I should say, on race relations in Canada, what it showed was there's a broad-based acknowledgement among Canadians that racism exists. But it's really conceived or conceptualized as an individual matter, not fundamentally about an issue of power relations, about systems and structures that exist in our society. But with our anti-racism strategy, what we're trying to hone in on is that systemic piece, and work with Canadians like you over the course of the next 3 years to ensure that our programs, our policies, our services, and our legislation are either corrected or adapted or amended to avoid or remove the barriers and systemic issues that remain here today in our society. And I think in doing that critical work, we cannot help being inspired by the Fred Christie case, because there it was, as has been mentioned many times, it wasn't the change or the momentum or impetus for change didn't start at the high level, at the top. It was really a groundswell of community organizations, of churches, of faith groups, and members of the university faculty and the student body who really came together to push for justice, to push for change, and to push against a fundamentally white supremacist society at that time. And what it reminds us also is the pitfalls or the risk of dismissing racial discrimination as simply a matter of personal taste. That's the way it is. These are just simple practices. And those who were victimized by racism and have the merit and courage to stand up are simply blamed for the incidents and the problems that they confront. Well, the Fred Christie case shows us that institutions and laws can actually be oppressive and be discriminatory. And so it's incumbent upon all of us, including the federal government, to do what is necessary to do. And so that's why in the federal Canada's anti-racism strategy, there are three dimensions. The first dimension is demonstrating federal leadership. So there's this understanding that if the federal government is to be active in the anti-racism sphere, if I can call it such, it must act by example. So demonstrate leadership by committing to removing the systemic barriers that exist, that continue to exist. And so that's why the Secretariat, which I direct, was created to assist all federal organizations to do that critical work. And the second piece is empowering communities. So that's the recognition that the expertise in terms of addressing and combating systemic racism lies with you, lies with the community. And so you need to be provided with more tools, more resources to do that critical work. So the government of Canada has committed $30 million over the next 2 years left, to really do that critical work through a variety of grants and contribution programs that are accessible to you for that work. And last but not least is the idea of working at people's mentalities. So changing attitudes and behaviors. And so that's first this recognition that sound public policy needs to be grounded in the data, disaggregated data. So there is disaggregated data that Stats Canada provided. As you might have seen that just a few days ago they released a really groundbreaking study on Black Canadians. But it's insufficient. That's what we're hearing from Canadians. So we've invested, the government of Canada has invested over $4.4 million with Stats Canada to do that critical work of providing more data and making it more accessible to the community. And the second piece, which many of you have evoked today, is doing that critical work of enlightening or informing Canadians that Canada actually has a racist past, and that racist past persists today in systems and structures, and has an impact on the daily lives of everyday Canadians who are from racialized communities, Indigenous peoples, and religious minorities. And so we're investing and we'll be launching next year a public awareness campaign that we hope to build with you to really build, to ensure that Canadians are fully aware of that history. But also with a bit of a twist, and I think Chief Commissioner Longfield, we had a bit of talk about this a few weeks ago, this notion that you don't have to be an activist to fight racism. And so that's what we're going to be grounded in the struggle that is kind of epitomized by Fred Christie and those who supported him, and this idea that everyday Canadians can be involved and have a role to play. And it's fundamental or essential to Canadian citizenship to be active in combating racial discrimination. So that is essential in a nutshell what we have as a mission. And as a secretariat, to really ensure that our public service is informed about systemic racism, we really were, I guess, inspired by the coalition that came about to raise awareness about the Fred Christie case, to ensure that every single public service, so this is our first step, that every single member of the federal public service is aware of the history. And so we organized on the 20th of this month a symposium at the Canada School of Public Service. So that's essentially the training ground for all the public servants. A session, a symposium on the case where we brought in subject matter experts, a legal and constitutional expert, to really sensitize the public service to that history. Some of you were there and participated. And we will now use the video as a pedagogical tool which will be accessible, which will be disseminated again to all the core public administration to ensure that it's a first step that they're aware. And we're going to be continuing that work of informing and ensuring that our public service at the federal level is making the right decision. But what is key to that process is really working with everyone in this room and Canadians across the country who have that subject matter expertise and that can ensure to keep our proverbial feet to the fire to ensure that we make the right decisions. So thank you very much. Congratulations, and I look forward to working with you over the next 2 years.